Madam, you know very well that
may it please your lordships first. Your lordships will find my written submissions, which I intend to follow, at volume 1.1, serial number 2. Page 31.
volume
1.1, serial number 2, page 31.
next one.
Because I intend to follow them, and I intend to skip large parts of them where I believe there is some repetition in light of what is already covered. So I'll be skipping many, many paras. Volume 1.1, serial 2, page 31. Page 31 in volume 1.1 is the second serial item, the second set of submissions. Surprised why it's not there? It's there on the record. Yes, yes. I'm also appearing in another matter in the batch, but that did not trouble your lordship. Now for the Sabarimala context, I'm in Travancore, there was some board. My lords have got it. The Honorable Chief Justice has.
Every other submission they are given hard copy, but you don't want to go back and forth.
No, but it is on the volume. Volume 1.1,
It's not
serial
available.
2, page 31.
It's not available, you go to it. 1.1.
1.1, no? Day one, it has been there, but I'm surprised your lordship is not. It's been there from inception.
Hard copy. Yes, they are given hard copy.
Hard copy may not be the ideal way of doing.
I'll go with the soft copy. 1.1 is come on this. 1.1 is it?
But you don't want to use hard copy.
Volume 3 also. No, you keep quiet. I have soft copy.
Justice Suresh has it?
Page 57, 58, 31.
Yes. Justice Amalwala has it. So, Malas, I will skip those parts which I.
Now you know the screen also. It is there on screen, main screen also.
To prompt. Now, let's A, I will skip as I said. B, it will be well, it's entirely on law. At the very end, I'll take 3 or 4 minutes to give you less than 3 or 4 minutes of factual context. Then, well, it's your lordship may not get the answers in the form in which your lordship's questions have come, but I have addressed everything which I've heard since the last few days. There will be, Malas, a slight digression at 1 or 2 places where I'll give a corrigendum hard copy in the light of what I've heard in the last, because Malas, these nuances change. So I've given a small, very short corrigendum at 3 or 4 places, which I'll hand over when I come to that place. Now, Malas, keeping this in mind, kindly come to internal page 4 of my submission, which is 34. I have dealt with it strictly issue-wise. My attempt is to give your lordships my answers to the issues. They may be wrong or they may be right, but they are my perception about the issues. And I've gone issue-wise with the way your lordship has framed the issues. So page 34 has the first issue. What is the scope and ambit of the right of freedom of religion under 25? Now, this, of course, is a very wide issue. I have tried to summarize my points in about 5 propositions, A to E, which I have summarized. The propositions on this head, on this issue 1 are: religion is a set of beliefs and practices followed by a group, sect, denomination with a broadly similar identity. While 25 clearly vests in an individual the right to profess, practice, and propagate religion, such individual rights cannot be allowed to extend to an area which intrudes upon the mass of individual rights of all other adherents of that religion or denomination. This is just a summary. I'll be elaborating these submissions in a moment. The belief, that's one. A. B, the beliefs and practices of the community have to be judged by the subjective belief of the community. The court is bound to accept the belief of the community, provided it is genuine and exists, well, obviously, not fanciful, not imaginary. And it is not for the court to sit in judgment on that belief. Third, it is impermissible to add, modify, or subtract from the specific constitutional text, and accordingly, the additional derogation or so-called derogation of essentiality as engrafted by some judgments is entirely impermissible. This has been dealt with, but I will only deal with that para of my note which has not been dealt with. Those cases not been dealt with. I will not repeat this. The permissible restrictions, that's the fourth one. The permissible restrictions, derogations from the right to practice, profess, and propagate religion found in Article 25 were arrived at after detailed and meticulous deliberations in the Assembly, and any other explicit or implied dilution of the right by interposition of other judicial restrictions would break down the delicate and intricate system of checks and balances envisioned by the framers. And last but the rights of persons under 25 are to be read harmoniously with the phrase other provisions of this part. So one cannot lead to vanishing point of the other is going to be my subject when I expand this. Your lordships may profitably skip the next page. Of course, for your lordships, leisurely reading, everything is useful. I don't think your lordship will have much time for leisurely reading. But anyway, Durkheim is quoted as a very famous writer on this subject about religion. But you can skip para 1 to 4. 4 is that Shirur Mat para where the footnote quotes, the lordship may write on the footnote number 3, relevant at 178, 179, about what is religion. And the fact that it's India-centric, India contextual, not foreign writers, they quote David Beeson. Now, I would request my lords to go all the way straight away to para 9. Not being touched yet, not being quoted yet. The so-called Oroville case, SP Mittal.
SP Mittal.
Observe, a constitutional bench, observe that religion is primarily a question of the consciousness of the community. It is obvious that religion, undefined by the Constitution, is incapable of precise judicial definition. Either it must be capable of overt expression in word and deed, such as worship or ritual. Keep the first qualitative ready. So religion is a matter of belief and doctrine concerning the human spirit expressed overtly in the form of ritual and worship. So I am answering my issue 1, point A only. It's only an A, which is your lordship's query subdivided into A. Now, Devaru, which has been read many times, I only want to emphasize this part, not the quotation, but the actual paragraph, that it is a much wider concept, religion, and includes all this 1, 2, 6, or 7 which I have listed. To think of religion only as a set of beliefs is wrong. It would include, for example, ceremonial law, installation of idols, conduct of worship, place of consecration, several classes of worship, how they stand and how they worship, purificatory ceremonies, and so on and so forth. It is elaborated in that para of Devaru, which is in my footnote number 10, in your lordship's relevant volume. These volumes are as per your lordship's nodal council, V.1, 239 to 240 in footnote 10. Once it is hyperlinked by your lordship's judicial clerks, it goes straight there. Now, Malas, a small digression is required, and I would respectfully, Malas, give a nuance to what Mr. Vaidyanathan argued on my para 12. A little different. Now, this will require a corrigendum. I'm handing it over. Give it to me. Seshmal is significant for the discussion of the principle that despite numerous rituals and ceremonies of the Hindu religion, which may have little nexus with objective third-party reality, rationality, and objectivity, they cannot be dismissed on the basis. So that is the ratio of Seshmal. Now, Mr. Vaidyanathan said that 16.5 was not looked at, and therefore Seshmal would have to be overruled. He cited 16(5). This is a short digression on that in my corrigendum. Kindly go to that. I want to harmonize Seshmal with Article 16 and 16.5. Yes, kindly hand over this. This corrigendum diversion will happen in 3 or 4 places only once, where it's necessary. So I'm taking a little different view. I'm suggesting that Seshmal can be harmonized with 16.5 and the rest of 16. Kindly hand over to my lords here, this side. My lords may have to do one thing on my written submission. Your lordship may have to write on this para, see also addendum A, so that lordship will know when to divert or when to. Well, let's go to the. Just write against para 12. C plus C addendum A plus C addendum A. Now, addendum A, Malas, which is the first page of my corrigendum. I'll just read it very quickly, Malas. Seshmal, which is the Constitutional Amendment of 1972, is valid for the proposition that diverse rituals and ceremonies of the Hindu religion must be treated as part of the Hindu religion. The purpose of this addendum is to differ with the submission of Mr. Vaidyanathan, where he has called for its overruling on the other aspect of non-appointment of archakas in denominational temples. Mr. Vaidyanathan suggests that had Article 16.5 been looked at, Seshmal could not have held what it did hold. Now, if you will glance for 30 seconds at 16.5, 16.5, it's important to see it, Malas, for just a minute, is meant as a derogation or an exclusion from 16, in particular 16.1 and 16.2. So just read with me, Malas, 16.5. Nothing in this article shall affect the operation of any law which provides for what, Malas? That the incumbent of an office in connection with the affairs of any religious or denominational institution or any member of the governing body thereof shall be a person professing a particular religion or belonging to a particular denomination. So in matters of public employment, which is 16, if a religious institution or denominational institution appoints anyone as a office holder or a governing body member, then it shall not be treated to be discrimination on ground of religion. Because just see 16.2, Malas. 16.2 says various Malas, grounds of discrimination are mentioned there. No citizen shall only on grounds of religion, race, caste, sex, descent, place of birth. So this one word religion in 16.2 is excluded by putting 16.5.
5 is an exception. To
Exception.
16.
That's right. Now let's kindly go. Most respectfully, the conclusion may not be correct for the following reason. I'm giving my submission now, Malas, in my A.3 in the corrigendum, in addendum A. Addendum A, page 1, A.3. Most respectfully, 16.5 is an exception to 16, which is limited to issues of public employment. 16.5 enables any religious or denominational institution to appoint anyone to an office or the governing body of that religion or denominational institution only if he or she is a person professing a particular religion or belonging to a particular denomination. So you can say that this place only Hindus can come, in this place only Muslims can come, and only Christians, etc. That will not be a violation of 16.5, of 16.1 and 16.2. Consequently, 16.5 is intended to be an exception to 16.2 and other parts, in as much as such religious or denominational institutions can restrict, by virtue of 16.5, appointments to offices or governing bodies. 16.5, however, does not immunize, this is my submission, from the charge of discrimination those appointed on other discriminatory standards of race, caste, sex, descent, place of birth, provided such persons are of the same religion and denomination as the institution. So suppose only Hindus are allowed, but then the institution says only Hindus from the north will come, not from the south. Only Hindus who profess a particular dispensation will come. That you can't do that. Religion is immunized, not the others. Seshamal,
There can be a case of discrimination within the same denomination, within the
Yes.
same sect.
you protect the religious character of that or the denominational character of that, but that does not mean you protect against every other form of discrimination. Now, next paragraph. Seshmal itself is instructive. Seshmal, everything else was held in favor of the institution. The only thing they said was that next in line succession is a non-religious activity. It's a secular decision that we are interfering with. Kindly read that. Seshmal was a case where an amending law, while continuing with the age-old practice and custom of appointment of archakas, who alone could perform the rituals involved, they did not change that. Abolished only the principle of next in line succession of the archaka. It said only the next man can do it. This was held by the CB to be a secular practice and a secular act by a secular authority, not infringing religious or denominational rights. I've given the page below 638 F to G. I'm not taking a lordship. This is directly held there in volume V.1. Consequently, even if 16.5 is applied to Seshmal, I'm now applying it, Seshmal can be harmonized with 16.5. Now this covers this.
That it is a secular act. The appointment process is secular.
Yeah.
But the person who is appointed ultimately is for religious performance.
Which has been upheld.
That is not secular.
Which has been upheld.
Dissect between the two.
No, what they did was.
The appointment process is a secular act. But he is appointed for a religious purpose.
So.
Entire thing cannot be secular. It's contradictory.
They are not saying that. They are saying that you will be able to be from that, you have to be from that community and you have to follow the requirement of only archakas doing ceremonies. That's the religious part. But to further provide that the archakas who alone will do the ceremonies must be the next in line, irrespective of suitability. That we are striking down. That is the limited point.
Where does the secular thing come there?
But that's the word used in the judgment is secular in the sense that this is not part of the requirement of the archakas to do ceremonies. That's how secular meaning non-religious. Secular in contrast to a religion.
Oh, the appointment process is secular then.
In a manner of speaking, yes, that's right.
In Seshamal, there's no, denomination was not there.
Yes.
Yeah.
That's a problem. Seshamal, mere belief was there. It was there by heredity by somebody, then where common could regulate it or not. If not, who can regulate? There's nobody to
That's
regulate.
right. But 16.5 covers both religion and denomination.
That's
Covers both fields.
That's all.
Now there's just one more addition. This completes my submission on harmonizing. There's an addition about this movement, this trajectory of 16.5, since we've discussed it. So I've quoted from the assembly debates on 16.5. This is just for information. The evolutionary trajectory of the 16.5, it was introduced on 4th November 1948 as Article 10.4. Then, because this is a religion exception, 16.5, so therefore I've just given the CAD. Professor Shah was the most prolific interrupter with queries. He was counted as the highest interventions in the CAD. Moved an amendment saying, I beg to move the clause 10.4 after the words in connection with the word managing be added and the words or denomination belonging to particular be deleted. The proposed amendment would thus read. So those two things are done and this is quoted. Then C. Professor Shah explained that the purpose of 10.4 is that the affairs of any religious institution concerned with the particular sect or denomination should be conducted by the people professing that religion or sect or faith. He further observed that 10.4 operated as an exception to the principle of equality in public employment and appeared to secure immunity or exclusiveness for the management of the institution of particular denominations, which the draftsmen somehow subconsciously have sought to provide. Then, this was an E, para E, negative. And then, draft 10.4, which is identical, the original draft, to the present 16.5, became a part of 16.5. That is just by way of finishing on this part. The Lordship can come back to my main submissions. Your Lordship is on page 37. So I conclude on my 1A, Malus, in para 16. I'm not reading 13, 14 and 15. At page 37, I'm not reading 13, 14 and 15. Now, I'm sorry, 38, para 16. From the aforesaid jurisprudence, it is evident there must be commonality in thought and worship to constitute religion. The common faith of the group sect community is that they follow common religious tenets, and there is a basic cord which connects them, would necessarily mean that the group sect denomination shares a common set of beliefs. While 25 clearly vests an individual right to profess, practice, and propagate religion, such individual rights cannot extend to an area where it intrudes upon the mass of individual rights of all other adherents. And I've just put this part of TMA Pi here. The general law, 11 judges, the general law made by the government contains provisions relating to public order, morality, and health. These would have to be complied with and cannot be violated by any person in exercise of his freedom of conscience or his freedom to profess, practice, and propagate religion. For example, a person cannot propagate his religion in such a manner as to denigrate another religion or bring about dissatisfaction amongst people. Well, Sardar Sayyadna, and all these are not read. I'm reading only those parts which are not read. Not one of these has been read. I've checked up on this. Sardar Sayyadna, it is noteworthy that the right guaranteed is 5 judges by Article 25 is an individual right, as distinguished from the right of an organized body like a religious denomination or any section thereof, dealt with by 26. Hence, every member of the community has the right, so long as he does not in any way interfere with the corresponding rights of others, to profess, practice, and propagate his religion, and everyone is guaranteed his freedom of conscience. The logical sequitur of the observations that religion, albeit in a limited sense, has its basis a system of beliefs or doctrines, is that religion is an institutionalized belief shared by a group of people, and every individualistic belief of a person vis-a-vis the system of beliefs or doctrines shared by the group of people would not be protected under 25 if it is in conflict with and undermines the beliefs. So, Malus, my summary now, which when I finish on 1A, is given in para 20. This is 1A. Religion, though incapable of precise definition, must involve a cohesive commonality of beliefs and practices for a community. Their beliefs, practices, and customs can be reviewed, if at all, where absolutely necessary, only by applying the subjective test of beliefs of the community itself, and only to the extent as to whether the belief or practice is in fact a part of that religion. So if you say that, look, this is something outlandish, cannibalism is a part of my religion, you should of course examine it, but not otherwise apply objective tests. It cannot be reviewed or tested by external, supposedly objective tests imposed by society or judges in an adjudicatory matrix. A large volume of rituals, ceremonies, practices, and other seemingly procedural practices would nevertheless be entitled to the full protection of 25, so long as they are held to be part of the religion concerned. 25 protects the common beliefs and practices of a community, not open to etc. I've dealt with that. Now, Malus, my second point under this first issue.
But we must add here, it is a religion essentially. Here it is relationship between man and God.
That is true.
So you have that is not there. Commonality in practices, beliefs may be there, but regard to what? It is in regard to
in all
not any
forms.
secular activity.
In all forms, no.
It is
This is a discussion of religion. It's a discussion
either
of religion.
spiritual or the relationship between man and God.
So it's a discussion on religion, not
Yes.
secular. So therefore, it's a given. I've not put it in that word, but Lordship has certainly add that word. Relationship man God, except that when you go into these special areas of Hinduism, whether Malus Charvak followers would also be considered 25 religious adherents is a question Lordship need not decide. Because according to Charvak followers, atheists would also be forming a religion. So that way, the man and God may not apply. But otherwise, your Lordship is right, it applies everywhere else. Then, Malus, the beliefs and practices.
Sardar gives a different perspective towards Article 25.
He says it is equally belief.
You don't affect others.
Non-belief.
Yes, yes. Your belief as against the
That is
world,
the belief.
but not within the denomination, or within the other beliefs of others.
But your Lordship did not have to do all that in.
There's no bar for you to practice whatever you want.
By and large, what my Lord has said, will apply that sentence must be there. It is implicit in what I'm saying. We were discussing religion, man and God or woman and God. This is the beliefs and practices of the community have to be judged by the subjective belief of the community, and the court is bound to accept the belief and not to sit in judgment. Now come, Malas, to para 23. Your Lordship sees I'm skipping a lot of things which are partly dealt with otherwise. Now, just the lower part of that para on subjective beliefs in 23, the Supreme Court went on to say if the tenets of any religious sect of the Hindus prescribe that offerings of food should be given to the idol at particular hours of the day, that periodical ceremony should be performed in a certain way at certain periods of the year, or that there should be a daily recital of sacred texts or oblations to the sacred fire, all these would be regarded as parts of religion. Well, as a lot of the other things I've given are also useful. I'm saving time. Your Lordship has the footnote. My Lord has the at page in the footnote. So anybody interested, Malas, can ask the judicial clerk to hyperlink it. But all of them are giving the same sentiment. But I'm not taking a Lordship except to a very few small parts. Para 26 is the so-called Ram Janmabhoomi case, Malas. 4 lines from there. Para 26. Page 42. Their page, not my page.
Okay.
We must firmly reject any attempt to lead the court to interpret religious doctrine in an absolute and extreme form and question the faith of worshippers. Nothing would be as destructive of the values underlying 25 of the Constitution. In para 28, Wallace, I made the obvious point that if you do essentiality, you are adding a 5th derogable standard. My Lord says 4 derogations by the framers in 25. Public morality, order, etc. Public order, morality, health, etc. And the 4th is other provisions of this part. So if you judicially engraft, as is being wrongly done, starting with Dargah and other cases, you are actually rewriting the framer's intent with a 5th derogable standard. That is impermissible. That's the point here. Then let us kindly come to here, Mullis, at this point, at para 28, I will not read 29. There is a discussion which is relevant here, which is, Mullis, at, this is 45? At page 45. Your Lordship will go at page 45 here. Because what I am now reading, C, links with what I have said. Then I'll come back to that. So C, Mullis, is that point, essentiality. Because this submission is a little bit out of sequence sometimes. So from that page, kindly come to page 45, para 33. Para 33. It is impermissible to add, modify or subtract, the point I made. My Lord has got page 45,
Yes.
para now. Now come straight to Malus, para 36. Page 46. Evidently, the words essential or integral are not to be found in Article 25. There is therefore no qualification or condition for the nature or significance of the religious practice, which is free to be professed, practiced, and propagated by all persons. Thus, all persons have a fundamental right to profess, practice, and propagate all kinds of religious practices, essential or otherwise. And last sentence of 37, to superimpose or carve out a narrower subset of religion as essential practices is therefore untenable. Yes. Now, there is a lot of useful material after this.
For what purpose this essential religious practices as a test was propounded by this court? To mean that only that is protected and nothing else?
It is no, I'll tell you. According to me, it is slightly loose language used in Dargah, which was picked up and taken as a doctrine. Let me explain a very important query. What they mean everywhere, possibly even in Dargah, is that we are entitled to decide whether it is religion or not. Your lordship is entitled to decide whether it is religion or not. As I said, I profess a practice to have cannibalistic approaches. You will not accept it just because I tell your lordships. Is it part of my religion? Is this religion called X supportive of this? That much your lordship will look into. That was perhaps by loose language or whatever, Malas, described as, is it an essential part of religion? So the test is, yes, by a subjective belief test, you must examine whether it is part of religion or not. Because anybody can claim anything outlandish. But
Just on this, just answer the query. In Shirur Mutt, the learned Attorney General
Was
made
rejected.
an argument
Yes.
that only essential part would be saved. They were discussing religious versus non-religious, not religious versus other anything else. But that contention was negative by 7 judges in Shirur Mutt.
Mr.
But that was picked up
Yeah.
in
Dargah
Dargah
committee.
committee, and they said that no, essential, if it is essential, then only protection of 25.
So,
That is not our-
Mr. Mehta, I was just coming to that. If we digress for a minute. Page 49 is where the Attorney General is quoted. And
In other words, there are only two parts.
Yes.
One is secular and other is religion. What you are saying, so far as secular is concerned, they have. So how the religion is concerned, it's
Yes.
you cannot be tested subject to 25 to.
Is it part of religion at all or not is the test.
That's
Now, well, that incidentally, I'm not reading it, but page 49 is that entire quotation where the previous page 48, I'm sorry, para 43 quotes the Attorney General's argument in Shirur Mutt.
Yes.
My para 43 quotes the Attorney General.
Yeah.
Verbatim.
Attorney General.
And next para, 40, next page, the submission of the AG was, however, rejected, observing, and then that is given there. The contention formulated in such broad terms cannot be think be supported. In the first place, what constitutes the essential part of a religion is primarily to be ascertained with reference to the doctrines of the religion itself. What 25A contemplates, not regulation, etc. Then all those quotations are given, and then Ratilal, which as we know came 3 days later by the same Malad's bench, except one difference, two differences, reiterates it fully, which I have also quoted in para 46. So,
So
Ratilal,
otherwise-
both are immediate ones.
So from the point of view of Article 25(2)(a),
Yes.
what is a secular activity which can be regulated by state? To that extent, you can say.
Is it religious?
Otherwise,
Is it
your
non-religious?
submission is essential religious practice test must be discarded.
So, why it was,
That is your,
the premise, exactly, I'm grateful.
yes.
The premise of the false premise according to me, is that yes, this is religion. But now I, the court, will see whether it is essential in this religion or not. And whether this is essential in the religion or not. That becomes a walk down a path which is full of problems. Whether it is religious or non-religious, or as your lordship puts it, religious or secular, is an inquiry, but that inquiry also is limited by looking from the prism of the religious adherent, not by an objective prism of a judge. That's the way it would.
One other way of saying it is, anything which does not come within the scope of Article 25(2)(a), it has to be protected.
Yes, except that 25(2)(a) may be a little limited, but many other things may be, but your lordship is right. It's the secular, non-secular,
Yes.
religious distinction. It's
But
another
the
way.
state cannot interfere.
Yes,
As brother said, it's only enabling provision.
yes.
So 25(1)(a), it restricts the role of the state, which means it protects it. Indirectly, it protects it that way.
So I'll be dealing with
State
25(2)(a).
will go into only secular activities and this.
Dr. Singhvi, just clarify on this,
Yes, just listen.
that an activity, naturally, religious is completely covered by Article 25. But when an activity has both a flavor of religious practice and also a secular aspect, how will the court define that activity? Will it fall in the religious category or it will fall in the non-religious category? Should we see the word essential from that angle?
Yes. So my submission is the following. Very pointedly, the answer to my lord's query. A, that is the unfortunate headache which your lordship has to face sometimes. In that very narrow number of cases where it's inextricably intertwined, as my lord Justice Bakshi puts it, between secular and religious.
Because let us say the example in Shirur Mutt,
Yes.
that I have to purchase ghee, I have to purchase, let us say, sugar
Yes.
to make offerings to God. Now, making offerings to God is definitely a secular practice. But in what manner do I make the purchase?
So,
Whether
that's what he meant. That's what he meant.
whether it will be religious or not, Sridhar connects it to
So let
religious.
me answer my last. So first point is,
There, Justice Mukherjee uses the word integral part of religion.
integral is the other word used. Integral is the other
Part
word
of
used. Yes.
religion. That if the activity intrinsically connected with the religious
My lord is
practice,
right. So
it
I
becomes integral part of religion. But then, if, let us say, sugar is purchased for performing some charitable activity of that religious institute, it also has a religious import, but it has a predominant
so
secular
let me
import.
try and answer that to the best of my ability.
Will we use the word essential
Yeah.
from that perspective?
So Mala's first answer is I don't want integral to take the place of essential.
But then that
I
is
understand
how
your
the
lordship's
word
point.
is.
I'm just giving you a lordship's.
It is true, the word essential
Yeah.
was borrowed from the Attorney General's submission.
I understand.
But
my lordship.
ultimately, when Justice Mukherjee delves into it, does not completely give up
No, I appreciate.
the idea of something intrinsically connected
So-
and something incidentally associated.
So Malas, one of the advantages of having a 9-judge bench after Shirur Mati is that at least everybody on this side commonly is canvassing that your lordship should clarify it beyond doubt, this way or that way. According to our submission, it should be clarified that the existence of that religious belief or religion is certainly in your lordship's domain, but on a subjective,
Yes.
objective test, not on an objective
The
test.
solicitor
That's
in
point
his
one.
submission has very succinctly said, it's a rebuttable presumption in favor of the section or the denominator.
No, I'll go further. I'll meet
No,
the lordship's
really-
query directly. I'll meet your lordship's query directly.
As my brothers put it, I think we can put it very simply.
Yeah,
If you read 25(2)(a),
yes,
it restricts the power of the state
yes.
only on 3 aspects, and the other you can read it on the principle of wisdom generis or solicitor generis.
Yes, yes.
It says economical, financial, political, or other secular activity. So the activity by itself will have to be secular. For example, running an institution, starting a party, doing something, constructing a building, renting it out. But it will not come under, as my brother said, the offering, buying sugar or buying other. That will become part of it will come under 26 also, the protection of 26.
Well, it's,
But when you do something which is on the face of this economical
so therefore,
like institution, you are charging,
Justice
you are
Bagchi,
admitting students.
Justice,
These things can be regulated.
Justice
But
Bagchi gave a
yes.
particularly
Not
difficult example.
anything to do with the prasad and other things,
No, it should be.
that will come under 26.
I'll give you a clear example.
No, I want to answer that.
Think
Let
of
us not
purchase of
too high
sugar.
and go into this.
It is definitely going into the bhog
Right.
of the deity.
Yes.
But let us say the religious denomination decides to have a bus purchased for carrying or ferrying devotees from a railway station to the mandir. Will that be a
So
secular
therefore,
or a
let me try and answer. Your lordship is very.
Associated with the religious practice.
So let me
No,
summarize my.
even without the bus, the religious practice, religion can go on.
Yes.
You also-
So, and that is where.
How it
what-
must
what-
be intimately connected with the religious practice. But it is a secular activity, then the state can still intervene.
So Malas, let me now summarize my response. Firstly, the distinction has to be religious versus non-religious is a better word, but religious versus secular is an acceptable word. That's my point one. I'm being as clear as possible. Lordship may Malas note my submission in whatever form. Second, that test I've already said has to be on a subjective objective approach, not on an objective approach. Number three, in either event, please eschew and eradicate the essentiality integral test, which has caused some confusion in the case law. A 9-judge bench can purify that. Number four, in the very, very close-knit examples given by my Lord Justice Sundar Justice Bagchi, ultimately it has to be a case-by-case decision. There can be no general answer. Number five, there is, however, a general answer in the flavor of every case. For example, ghee, should I purchase it? which quality ghee will please the deity. Deity cannot have anything, etc. Will remain within the Devaru and the so many other judgments of religious practices. However, in the purchase of ghee, if you are clearly going to the highest seller, one person is selling at 10 rupees, same ghee selling at 2 rupees, and you are pocketing the difference, and the state makes a law to audit those accounts. And that is not a ghee question. That is an accounting question. And it must be secular. It must be regulatable. Now, in most cases, according to me, your lordship's plus talents, judicial talents are able to sift the chaff from the grain.
That's
There is
what
no general answer.
Chief is also saying.
Your lordship can make out.
It's,
But your lordship has to be careful with the language of 9 judges because that binds us all. And that will also bind Shirurma, it will also bind Dargah. And that clarification, it will happen in all the bus example, for example. I would say, Malas, that the intention to ferry pilgrims to a very place of high religious repute may also be religious. But how you purchase the bus, you do all kind of accounting malpractices there, or you overdo it. You take a Mercedes limousine to start taking Sabarimala, Malas, where you're supposed to walk barefoot.
absolutely.
Those are your lordship understand those distinctions. You understand those distinctions.
Certainly, we will not be able to explain
down a
all on
general-
illustrative or hypothetical basis.
Yes.
We can only lay down the broad principle based upon the
But
constitution.
I believe that your lordship's language is sufficiently flexible and yet tight to deal with such marginal situations. Most of them are not marginal.
Case basis.
Yes.
Ultimately, under section, Article 25(2)(a), religious practice is not to be touched.
Yes.
You can
Yes.
regulate anything,
Yes.
but not a religious
You
practice.
cannot say, look, this religious practice is wasteful. This religious practice need not be done. What is the need to do all this to the deity? This religious practice is excessive. This is extravagant. Those are not your lordship's domain. Cannot be. That's all right. Now I will jump from that earlier para, which is dealing with all of this. So this in fact, with quotations, it is dealt with, Malas, from the trilogy of cases. I've said it, para 41. Para 41, I've used the word trilogy. That is page 46, 47. One page. Which is called trilogy Shirur, Ratilal, and Devaru. But I'm not reading it, Malas. Then I've given the extracts in all this. Then the AG's argument and rejection. And then quotations all the way till para 47. Page 50. I'm profitably saving time and not reading all of that. And I'm coming straight to para 48 at page 50. You keep the page number open. At page 50. It is a common misconception to derive essentiality of a religious practice by reference to economic, commercial, or political activities or activities of a secular character. These activities are mentioned in case law, not for the purpose of determining essentiality, but as a contrast to them. This is my harmonization or my submission. This is the way, of course, there are some errors. But in other words, these activities are cited precisely to illustrate what does not constitute a religious practice.
Yes.
Not essential or non-essential. Religious or non-religious. That's the purpose. The test is religious, non-religious. Other words, Shirur Math draws a contrast between religious and non-religious. This is vastly different from saying that the same case supports only essential religious practices within the field of religious practices itself. The case law does not undertake any such bifurcation within the domain of religious practices into essential and non-essential. Rather, the judgments contrast two distinct and non-overlapping spheres, one comprising religious practices and the other comprises non-religious or secular. Examples of the latter would include maintaining ledger accounts, administration of temple, filing income tax returns, etc., etc. At no point do they divide, etc. This then the error I have told, elaborated, which comes from Dargah. We are skipping 4 paras here. Dargah is quoted how the error crept in through Justice Gajendra Gadkar's judgment. Your Lordship may come to para 52, page 52. The only inquiry required to be undertaken before the freedom qua a belief or practice is accorded protection under 25 or 26 is A, the belief genuinely and conscientiously held by an individual as part of a group or a denomination. Is it a genuine, real belief? Is it just kind of somebody's wild imagination? If it is so, is it so held as being part of a profession or practice of religion? Once the above tests are satisfied, the freedom qua belief or practice is protected under 25 or 26 as the case may be. No outside authority has any right to say that they are not parts of a religion inter alia because they are not essential. It is not open to any secular authority of the state to restrict or prohibit them in any manner. But this para 57, why did you go into class one?
Dr. Sengvi, paragraph 53.
Para 53 was?
But it is not open to any secular authority of the state to restrict or prohibit them. Do you mean that 25 2B is also excluded?
No, 25 to be lost.
So
25 to be
that
lost.
is-
Just keep aside, it's coming in detail.
Please, sir.
No, it's coming in detail. I'm not going, it's
No.
coming in great detail.
We got,
Yes.
just wanted a clarification because you used the word any secular authority.
No, but therefore, I'll just in a short while, I'm coming to that. Lordship, just park that point on 25 2B. Your Lordship is right. I'll just deal with it. Now, Mills. 55 is important for Dikshitalu, but I have given the conclusion on that in 57. This sheds some light on your Lordship's secular, non-religious, religious issue. In light of the foregoing discussion repudiating the essential versus non-essential, way 25 2A may be interpreted and understood by the present 9-judge bench in the following manner. The state, this is my suggestion, my submission. It's only my, the state can make laws regulating economic, financial, political, or other secular activities. Exactly what my lord just said. Justice Sundaresh, Justice Nagaratna, 25 2A formula. Kind of thing. This does not mean that the state is permitted to intrude in what is admittedly considered by the individual or part of the religious group or religious denomination to be religion, religious beliefs, or religious activities. Though, next page, para C. No, though mischaracterized by case law starting from and after Dargah, misinterpretation of Shirur Mat, this is not the same as saying that laws can regulate non-essential religious activity. That's my problem. That's the problem I want to address with us. In view of the error of the essential versus non-essential classification, this bench should clarify that it means that what the law is regulating under 25 2A is not religion at all. Therefore, there's no question of essential, non-essential.
Whether it's religious or not.
Religious. Once you're under 25 2A and those 4 words, then you're not religious. The regulation is limited to economic, financial, political, or other secular activity which will inevitably arise in connection with an associated religious activity, since the latter can never operate in a vacuum. This approach would harmonize with the true spirit of Shirur Mat. Yes, fellows, I bow down. Justice Bakchi's observation was integral. It will also harmonize this. Your Lordship will not allow use of words like integral and essential anymore once Your Lordship harmonizes. Otherwise, fellows, integral will become a substitute for essential again. Your Lordship will have that. And last parameters.
Used interchangeably.
They'll
They're used interchangeably.
begin to be. The idea, last para on this point was 58. The idea of an inquiry into the essentiality of a religious practice, anathema to 25.1. If it is only a religious practice is contrary to public order, morality, health, or part 3, it may be interfered with. It may be, even though it may be considered to be essential to that religion. So if it is essential, Your Lordship still applies 4 tests: order, health, etc., and other parts. If, however, a practice is not offensive to public order, morality, health, is another way of putting it, then Your Lordship still says, though it is not essential. A practice is found to be in the religion, it is found not to be public health, public order, morality, other provisions, but yet it is excluded because of essentiality. That's wrong.
No, on the other, it is like saying, because it is essential religious practice,
Yes.
even if it is against public order, morality, or health,
Yes.
or other parts, it should be protected.
No.
That is one way of saying
So
it.
that's why I'm cautioning.
Yes.
The moment Your Lordship uses
That's
the
why
word.
it's not necessary to go into that.
No, but the moment Your Lordship allows the use of the word essential, or for that matter integral, Your Lordship necessarily starts operating within the subsuming or rubric of a concept called religion. You have to divide and categorize religion. Without that, you can't do it. We are against that. Your Lordship can achieve exactly the same results of regulation either by using the test of 25(2)(a),
Yes.
or by using the opening words of 25 itself, which says 4 tests, or by saying that what is religion, you decide by a subjective objective test, and the rest you put away. So your lordship achieves the same thing. Otherwise, Malus, your lordship has a lot of confusion. Then people, Malus, start, then in fact, it becomes a license to permit judges or external adjudicators to decide the essential and non-essential component of what is religion. That cannot be, Malus. At least anathema to this side of the arguments, Malus.
There can't be a tinkering like that.
Yes. Then Malus, your lordship don't know where to stop, Malus. Then it becomes a long journey inside. Lastly, this completes this part. If your lordship will give the 2 paras left at page 43, because I jumped from page 43 to this. Just see the first 2 paras at page 43. Para 29. Give me pani. Page 43, para 29. This is where Lordship went ahead with me. So I've come back to that page, para 29. Lastly, a legitimate query may arise as to whether the court's review is so minimal. Well, I'm being very argumentative and I'm giving my submission and answer to your Lordship's queries. So whatever this is, so I'm putting a hypothetical question. Is it so minimal and so self-denying that even an absurd practice proclaimed by religion, eating only elephant meat or eating only human meat, should be non-reviewable because it is part of the bona fide belief of a person who claims to be an adherent of the religion? The Lordship has got this argument put against the fact. Why are you arguing this? You have to look at essentiality, because otherwise you could have these kind of absurd things. So I'm answering that. This seemingly extreme proposition does not in any manner derogate from what has been stated by me till now. Why? Firstly, if the belief, an extreme one in the above example, does not form part of the collective institutional and denominational belief of a group or sect belonging to a religion, it will be rejected not because of an objective external standard, but because it does not constitute religion at all, since it does not exist in the collective of a group, but is asserted only by a few maverick and eccentric individuals who claim to be adherents of a religion. That is one way of dealing with it. Second, alternatively, in any case, it would be hit by a lordship's textual derogations available.
Public order.
Even if
That's why the framers thought of that balance. They thought of virtually covers anything of that crazy kind.
Even if the denomination believes, it
You
can
got those
always
three.
go under subpara.
Why have this essential, non-essential, integral, non-integral?
Yes.
Then well, next third. However, now I'm giving another extreme answer, just for the proposition of law. However, notwithstanding the above, if there is in fact hypothetically a religion whose collectivity genuinely believes in and can trace back its lineage to the factual and genuine existence of such practices, then the courts, having found that such a religion does in fact exist, cannot set aside such practices on personal or subjective judicial notions of aberrant behavior or impose external societal norms. Except one of those 3 words in the 25, that goes without saying, obviously. They would, however, be fully entitled to examine whether such practices fall under the 3 above standard heads. Conversely, if we now take an example of what might well be an abhorrent practice by normal, average and external standards, but is genuinely believed to be a core part of a known and established religion, then the application of 25 in its full platitude becomes clear. Now, I'm not giving the example because I'm a Jain, but this is a very good example. In any form of obscenity and morals, you cannot be allowed to roam naked. Digambar Jains, even today at big functions, the actual sadhu will come completely naked. And there are a large number of women at that function who are actually doing the principal honors. I have myself been at this function. Now, Digambar Jain, by that set of standards, should be abolished. It's a very good example for the extreme proposition, because nudity in all other forms is proscribed. But it is nobody's case that Mahavir, who was a elder contemporary of Buddha in 6th century BC, and who was the 24th Tirthankar, That religion, which then branched out to Shwetambar, there are so many brothers, Bhakti Marg, non-Bhakti Marg, etc., etc. This whole thing, brothers, will be abolished because of some external standard which your lordship find abhorrent.
Therefore, it's not constitutional morality, but public morality.
So an actual example of a
Finds it abhorrent.
an actual example of a denominational sect called Digambar Jains is a very good example to test it. Now kindly read further.
Naga sadhu.
And
Naga sadhu.
Naga sadhus, yes, Naga sadhus. At the Kumbh Mela, we have all been to Kumbh Mela, we have seen it. Now, this example comes from the significant Jain sect of Digambars who hypothesize are called skyclad. The word Digambar means skyclad. Ambar is sky, means. Who, as the latter word's literal translation suggests, are obliged to be skyclad. There is no doubt that nudity is abhorrent to normal canons of civilized behavior. Yet, since Digambar Jain practices, including nude existence and nude movement in public, are undeniably accepted as a core part of a well-known religion, it would not be liable to be struck down. 125. Then, para 32 is my summary as I end this part. Para 32. A summary is practices and beliefs of a religious community must be judged by courts purely applying a subjective test, not external objective. Courts cannot and should not rewrite practices and tenets of a religion or rationalize religion. Well, this is, of course, Justice Malhotra in the dissenting view in Sabarimala now under review. Factually established religion and religious practices ought not to be subjected to judicial interpretation, Ram Janmabhoomi judgment. Well, I put a different angle in D, Manas. I've tried to put a different angle in D. These principles harmonize and effectuate the primacy given to fraternity. Was one word of our constitution which has received the least attention. There is only one word which has become bigger than all other words of preamble without being in the preamble is federal. Well, I googled the constitution. There is no word federalism or federal in the entire constitution. Federal comes only for the federal court. So your lordship has held to be part of the basic structure, a word which doesn't occur in the constitution. That is the greatness of our evolving jurisprudence. Federalism is part of basic structure from Keshwaranand and from Bomai. It's nowhere found in the constitution, the text, not a word, in the longest constitution of the world at that time. Now, Malas, fraternity, though a word in the preamble, is the least used, least applied, and least, if I may say so, spoken about or,
Least understood.
yes. I would say, Malas, that this concept of religion must, somewhere cross-fertilize with fraternity. Without that, this doesn't work. Actually, the most important part of the preamble, which works with 25-26, is this word.
Belief, faith and worship.
Justice Nariman has given a very interesting lecture on fraternity some time ago.
There's also freedom of faith and worship.
I beg pardon?
A freedom of faith and worship in the
Belief and liberty.
Yes,
and worship.
liberty of thought, expression, belief, faith, and worship. Yes.
So if you see, belief and faith is internal, worship is an external expression.
No, why I didn't mention it, Malas? This sentence of the preamble has found full expression in 25.
25.
Fraternity has not. I'm picking out fraternity as well as a cross-fertilizer because liberty word here before equality, which we have taken actually from the West, from French Revolution documents and the American Constitution, Jeffersonian words. But liberty is fully elaborated in 25-26.
Yes.
This liberty of thought expression, belief, faith, and worship. But fraternity, which is a very important part, is less. That's what I'm saying.
But then Mr. Singhvi,
Yes.
Dr. Ambedkar said that though it is said or normally said that it is taken from the French revolutionary principles, fraternity, I am impressed by the Buddhist ideology and from that I take the word
Yes.
fraternity to the extent which the Buddhist,
Yes.
Buddhist ideology describes. So it makes it clear that it's not from the French.
No, he has not taken it. That's true. He has not. These words have come in constitutional documents from those revolutions, but your Lordship is right. I don't know which year he converted to Buddhism. Maybe at that time he had already, I don't know, 55.
55.
Later he had converted to
55.
Yes. Formally in 55.
56.
56.
55, 56.
Once a belief of...
Or with regard to dignity of the individual.
But without a fraternal concept, this religion concept of others' religion
Therefore, Mr. Singhvi,
function.
he refers to the principle of Karuna.
Karuna, yes,
Which
yes.
is more,
Which is a
more
very
wider.
Buddhist
What
concept, very
normal
important.
says, we will say fraternity,
Much more wider.
much more wider.
Yes, yes.
Expression used was Karuna.
Karuna.
Compassion, karuna.
Compassion.
Kindness, beyond kindness is karuna.
Compassion, yes, please.
The idea
One-
of empathy.
E, Manas, at page, what is this page? 45. Once a belief or practice is found factually established in what is accepted as a religion, then any further judicial application of a supposed essentiality test would amount to engrafting onto 25 and additional. This I have done already, Manas. Any hypothetical, absurd, or reprehensible practice would frequently be excluded at the threshold by not finding the collectivity concerned to be a religion at all. Other similarly reprehensible practice would fall foul of the 4 derogations. However, if a seemingly or alleged absurd or reprehensible practice does not fall foul of F or G above, then it cannot be struck down by the courts if it is otherwise found to exist as a custom, belief, and practice of religion concerned.
Now, please tell us now.
Yes.
Let us test this with the amendment brought by them.
I beg your
And,
pardon?
yeah, with the amendment brought by them under the Hindu Succession Act.
By the
Section
Hindu
6.
Succession Act.
Section 6.
Yes, take it out, please.
So now, the belief is with respect to co-partiality. It comes from the principle of the Sapinda principle.
Yes, yes, yes.
Now,
yes.
Now, under which provision that the amendment to section 6 would come where the concept of co-personality has been removed and consequently the Sabata principle has been given, in effect it has been given a go by, giving equal right to women. Will it be traced under which provision, which under 25? 25 to be.
25 to, yes, yes.
That's right.
Yes.
That is, so 25 to be, even assuming that there is a religious practice, I believe,
Yes.
to that extent we can acknowledge
Yes,
their
yes.
right.
And I'll be dealing with that 25 to be shortly, but lots of query also. I'm just coming to that.
Article 15.3 also. For women.
Yes, yes. Now, Melissa, the next page relevant is page 55. We've done those A, B, C. Now on D at page 55.
And explain at what extent courts can interfere. See, if Article 25 says that it is for the state to enact a law, but as my sister put it, it is say one is with respect to the existing law, and then the other parties to have new law. What extent can the court go into? Should we confine ourselves with, supposing they say they taken only action, state brings out legislation under 25 2B, saying that it is against social belief or something like that. To what extent can the court substitute it and strike it down as saying, or we can go into the parameters adopted by them,
Yes.
or we can we go and say that no, it is not actually one which is can be exercised under 25 2B.
Yes.
I think this is going to be the problem with which court will be able to.
I have dealt with it fully with a specific point wise, but just to anticipate for 2 minutes, your lordship's query and answer it now. This different section.
There are two situations where somebody can approach a court directly in the absence of any legislation.
Would my
Then
lordship-
what do we do?
Yes.
And when legislation has been brought in and it has been challenged, then what extent now we'll go into the issue of social welfare and
Yeah,
or
never mind,
social
never,
reform.
never. I was, have dictated and so let me just digress. It's coming later. Let me digress for 2 minutes and give you a point-wise reply to the greatest degree of specificity I can muster. It's an important issue, 25.2b, which will link not only with 25.2b, but will go to 26 also. They're all coming in the issues later.
Yes.
But Wallace, to give an immediate answer to my lords, my submission, as blunt and as specific as possible, is 1. 25.2b has to be limited to quote unquote throwing open of Hindu religious institutions of a public character. 2. Therefore, the word entry has to be governed by 25.2b. All forms of entry, main gate, compound, access, no doubt about it, to the exclusion of 26. It's a specific derogable thing, access must be covered. After you enter, for almost everything, 26 will take over. After you enter, now, I have entered, brothers. I am this class, that class, I'm not allowed to enter. Law is there, no question. You can't keep me out under 25(2)(b). After I've entered, I've dealt with it fully, I say I have a right, equally having entered, to do worship in a particular way in the sanctum sanctorum. Why not? Because I have access, I have come inside. There 26 will take over. If the collective belief of that religion or denomination does not permit anybody except him to do malus worship in the sanctum, then I can't insist. Some do, some don't. It varies. Then there's a third angle to this. All what I've said here will not apply to a truly private temple. That's a term of art. Well, this is not what we think. Private temples actually are very few. They have to be genuinely private. There are a lot of private, so-called private temples which become so famous by custom usage and over the years, and the footfalls and the veneration has increased so much. They're actually public temples. In a public temple, all these principles apply. However, obviously, in a home private temple or somebody's own domestic arrangement, this will not apply. Neither 25(2)(a) can be made, nor 25(26). So I'll harmonize. It's coming. I'll just come to this summary and it will harmonize. I've been trying to harmonize in every part of my submission. 25(2)(a), 25(2)(b), 26. All these values will have to come.
You are saying that 25(2)(a) is sort of an exception to the freedom under Article 26.
25(2)(b). My lord was asking about 25(2)(b). He asked about 25(2)(b).
25(2)(b).
B is an exception in the sense,
Exception.
for all issues regulating entry, you have to go to 25(2)(b). Once you enter, 26 takes over. You cannot regulate entry. Well, otherwise, under 26 also you can regulate entry.
So that is
Why not?
right.
Why can't your lordship regulate entry in 26?
Argument as compared to Mr. Vaidyanathan's argument.
Yeah, that's correct.
Only for public institutions.
I have written here that I respectfully disagree with my valued colleague on this point also. I've written my note. At the end, he suggested that you can exclude altogether by the beliefs of that denomination.
Yes.
So I don't think that's true of entry. Not only because our founding mothers exerted very strongly to insert 25(2)(b), but otherwise, it would make nugatory a very large part of our debates, which was intended. The whole idea was, actually at that time, the kind of practices deserved that kind of approach. But then you are carrying it too far. If you start tinkering, having entered, then everything, how puja will be done? Who will stand in line first, or I'll stand last? Then I will go to sanctum sanctorum also, because I have entered. I have a 25(2)(b) right. Therefore, I will take the 25(2)(b) right into the sanctum sanctorum. That 26(b) will stop, depending on the denomination lordship is considering.
One more example we can say.
Yes.
After all persons enter,
Yes.
there cannot be a discrimination when it comes to serving of food. That only a particular caste people should sit in one room, other caste people should sit in another room. That is also forbidden within 25(2)(b). There can be reform on that.
There your lordships will be anyway covered by 14, 15 and 16 also.
So we are saying.
Because other provisions of the part also will come in.
Reform in that.
Yes. Now it may be some very delicious questions, where a denomination says, I'm giving you extreme examples to test the word. This is not going to be, and not beyond lordship's reach also. Extreme denomination says, having entered, which we can't stop, our denominational rules require, as the lordship says, for all to stand in a separate part altogether, about 100 yards away, and by telescope view the deity, or kind of not come anywhere near it. Now, that will not be justifiable under 26(b). That's an extreme example. Yes. They will claim 26(b), but I don't think that works for us. Those are extreme things the lordship can handle in individual cases. That's not really a way of dealing with. Extreme examples can distort. May I come back to page 45? Page 55, I'm sorry.
D.
55D. Now, this is mostly covered, except that I'm just turning the pages to your lordship. I have completely traced the debates on this from the CAD on these issues, which your lordships can skip. And one correction by hand your lordship may make, 66 para to 68 para, your lordship may cut off because they are repeated in para 110, 111. Your lordship can by hand cut it off.
60.
So, well, from page, section D where your lordship starts, my lords can skip the first 2 pages. When your lordship comes to the 3rd page, which is page 57, your lordships can even cut para 66 to 68 because they are later on elsewhere also.
Oh,
Now, let's. Where do you go now?
So page 59, 29, TMA5.
We straight away come to page
Page 59.
59,
50.
TMA pi. They are also useful. I quoted Dikshitalu and all, but I don't have time to read everything. But come to TMA pi.
Cell number F.
Yes. Article 25 gives to all persons the freedom of conscience and the right to freely profess, practice, and propagate religion. TMA pi was 11 judges. This right, however, is not absolute. The opening words of 25(1) make this right subject to these 3 words, which Lordship knows. This would mean that the right given to a person under 25(1) can be curtailed or regulated if the exercise of that right would violate other provisions of Part 3 or if the exercise is not in consonance with public order, morality, and health. The general law made by the government contains provisions relating to public order, morality, and health. These will have to be complied with and cannot be violated by any person in the exercise of his rights. No. So I now end on para D actually. I'll just end on para 75 because D is mostly covered and quotation. So para 75 is my summary on D. My summary on D. Page 62. All of it is summarized fairly here. I don't need to trouble your Lordship with para D. So para 75, page 62. The derogation specified in 25(1) can be effected only by law. Well, we tend to forget this. It can't be some kind of a casual derogation, by a diktat, by an executive circular. This is important. Many speakers in the debates, including Mr. Munshi and Lakshmi Maitra, articulated this facet and assumed law to be implicit in the structure of 25. 25 then was Article 19 at that time in the assembly. Diverse judgments, Shirur Mutt and Sayyid Sayyadna included, have treated the derogations to be part of the sovereign power of the state to regulate through law. Through law. Freedom to profess, practice, and propagate religion was treated as a fundamental constitutional virtue and an interpretation which allows derogation only by law, which alone would be consistent with the high status. I'm emphasizing law again and again. Would my lords write against B? The quotation from the CAD, Mr. Munshi and Mr. Maitra, are in my paras 61 to 65, which I'm not reading. Lordship may just counterlink it. In B, your Lordships can write. See also paras 61 to 65, where I've quoted them, just for your references. I've quoted Mr. Munshi and Mr. Maitra and others. 61 to 65 of my this note itself, just a few paras earlier, but don't read it now. The actual debates about law. Then E. The word law would not unduly limit or fetter the discretion of the state and not attenuate its elbow room and flexibility to regulate, because law, Malas, is not law as we understand it. It includes delegated legislation and everything under Article 13. 13 is an expansive definition of law. So it's not to think that it's inflexible. To allow derogation in respect of as vital and significant a fundamental right as the right to religion by ad hoc and mere subjective executive instructions, orders, and directions, not having the trappings of either law or delegated legislation, would render susceptible such an important fundamental right to dangerous executive invasion. So Lordship cannot be too loose with the word law. The Lordship has to be strict in the light of 13 otherwise. In the context of the aforesaid larger objectives and perspectives, even if a doubt existed as to this issue, which I submit does not exist, constitutional courts in the 9-judge bench should adopt a teleological and purposive interpretation to subserve the object of strengthening the freedom of religion. My last point, Balats, on this.
45(1) is subject to public order, morality, and then health. There is a need for a law otherwise. No, what you can't do, when your right itself is subject to that, it can be restrained by an executive order and directions, you know, when you no need for a law as you are contemplating. That might be required when it comes to 25 to A or B as a case may be.
Yes, because
Not for other things, because when it come to public order, morality, and then health, you are not supposed to do it, then they can regulate it. See, there is no question of regulation.
no,
It prohibits you.
so I'm only emphasizing that this is
Therefore, you
subject
can
to Article
segregate
13.
it.
Article 13 is there for all these parts,
Yes,
the whole
but
part.
It actually, see, your right is itself subject to that. Where is the question of Article 13 being applied there?
Yes.
They have sufficient power to do it otherwise, because you are not facilitated to do it. It is have been prohibited under law under the Constitution, Article 25. You may be right when it comes to 25 to A or B. To that extent, you are right.
No, that is one part.
Existing law or law to be promoted, and then secular, and then on a social welfare
That
or
is one part, certainly. That is
or
one
social.
part.
That's a different thing, because it's a bit too high.
Yeah.
That's what they think. Thank you.
Right. Now it is E.
Existing law will also include a custom or
Yes,
usage.
those are those pre-constitution.
They are protected.
Yes, yes, they will have to be covered because what is existing will be here. Now it is the last part of issue 1. Issue 1 finishes with E. Now this is the other provision of this part. It's a little difficult, Balas, so we have to, my approach is to harmonize it. Otherwise, your lordship, Balas, the short point before I read this E is that yes, now we're not talking of three things, Balas, public order, health, morality, we're not talking of. Other provision of this part cannot be a catch-all phrase to reduce 25(1) to vanishing point. That is the point I'm making. You have to be harmonious, otherwise you'll end up reducing 25(1) to vanishing point. That can't be. Now, let me elaborate on that. The fact that the right under 25 is made subject to other provisions of this part does not and obviously cannot mean that any individual exercise of the right under any other provision of Part 3 can extinguish the Article 25 right completely. Nor can it mean that the exercise of rights under other parts of Part 3 can significantly reduce and attenuate these rights. The individual exercising other rights cannot either extinguish or dilute the right of the collective rights provided in 25. Consequently, the only way to correctly interpret the constitutional language is to apply 25 on the one hand and other provisions of Part 3 on the other in a harmonious, reasonable, and balancing manner, while always remembering the anchor provided by the three broad heads of derogation. That anchor you must keep in mind. 79, para 79 at page 64. Given below, descriptively and as a summary, is the constitutional trajectory of the phrase subject to other provisions of this part. Now, the first was in 13 December 46. Just a few minutes here, and it's important, Malis. So this formulation in December 46, right at the inception, was subject to law and morality, the last 5 words. It had no other parts of this part, other provisions of this part did not have. Lordship's got that one? 79, did not have. Then number 2, Mr. Munshi said, in a manner compatible with public order, morality or health. Incidentally, there is nowhere in the Indian Constitution the word compatible used. I've checked that out. That's why Mr. Munshi's proposal did not succeed. He put in the word compatible. But again, it was public order, morality or health, not other provisions of this part. There is nothing there.
Where are you reading, please?
I'm sorry. I am on Wallace, para 79, page 64.
Yes, yes.
The original draft is I in December 46, which is different. It doesn't even have, it has only law and public morality. It has neither other provisions nor anything else.
Yes.
Second version is manner compatible with public order, morality or health. I've underlined it in double I. That is Mr. Munshi. This is March, Wallace, 17th March 47.
Yes.
Now, Wallace, next triple I. Dr. Ambedkar, Wallace, triple I. He also continued with the compatible formulation of Mr. Munshi, and he said within limits compatible with public order and morality. Now we are having two here. Public order, health is not there, and other parts is not there. Well, there is this is a little strange here, Wallace. It appears that this model was being adopted. the Munshi Ambedkar. Dr. Ambedkar did not have any major problem with this. But there is a sudden change, in many ways, in number 4. On 29th March 47, there is a subcommittee on 29th March. We don't know the reasons how, but it changes to this. In a manner compatible with public order, morality or health, and with the other rights guaranteed by the Constitution. This two words, health and other rights, came together. And I searched for us. I have no particular reason to find out what happened. This fellow, Lordship will note, is only 3 days later. 29th March is 3 days after Dr. Ambedkar, 26th March. I hope your Lordship has got that.
Yes.
So there is no particular reason we can find in the debates why this happened, but somebody made it more comprehensive.
It's not debates, there's subcommittees.
Yes, so it's going in and out of subcommittee.
Formulated.
Yeah, correct, but that's how it develops and comes out in the assembly, because that's ultimately what finds favor in the assembly. Then,
Only one addition.
certainly.
In my written submissions, page 31, we say.
Some objection here. Can the solicitor interrupt and add on whenever he wills? If that is so, all of us can. You can't just keep
Mr. Dhawan.
elaborating your argument.
Mr. Dhawan,
No greater than any.
Mr. Dhawan, probably,
Do not let me state that for the benefit of the solicitor, not your lordships.
Then, on 3rd April is the next item, number 5, at page 66.
This is the reason.
Article-
Just give the page.
there also continued and to the other provisions of this chapter.
So now, compatible goes. Actually, compatible is nowhere in the Constitution. So they make it probably.
And the other provisions of the Constitution disappear.
And consider the other
And-
chapter,
and
this
the-
chapter.
And to the other provisions of
So
this
they are the
chapter.
new- Exactly. So the whole Constitution versus this part.
Yes.
Subject to versus compatible. And only law and order now has morality and health. Three evolutionary trajectories. Now, there is, not here, but at a particular page, in Mr. Mehta's submissions, he's just shown me, page 31 or page 28. There is an advisory committee headed by Sardar Patel, who gives an interim report, but that's later, much later after this, 23rd of April. And there again, they have subject to public morality, order, morality or health, and to the other processes. So they maintain this. What I have given here is maintained. And so Chief Justice mentioned is very important chapter or this part, not the whole Constitution. Then come to number 7, my small Roman 7. Further interesting to note that despite the existence of the phrase subject to the other provision from early as April, and despite detailed discussion of all substantive aspects of freedom, no discussion can be found as to the reason for the insertion of this phrase of this chapter. That's all right, whatever is there. My conclusion now is, consequently, in view of the tabula rasa presented by the Constituent Assembly on the rationale underlying the use, the reasoning given as to how 25 must be harmonized and neither attenuated nor decimated is your Lordship's prerogative now. There's no particular light which they throw on us that your Lordships can't do it. They are not suggesting that Lordships can or cannot do it, so there's no restriction on Lordships doing it. Your Lordships, I believe, is on a tabula rasa here. Now, is this here? Not here, no. Which is the next para now? 84 we are skipping. Why do you confuse me? 84 is later, right? Now, I will skip. There is one para here, 84, which your Lordship may.
83 may be instructive.
I'm grateful. Noting the absence of the phrase other provisions of this part in Article 26. The Supreme Court has in several cases made every effort to harm. So that's the law. I'm grateful, very grateful. Your Lordship, and give me a minute, I should have mentioned this, fellows. Your Lordships has in footnote 75, sorry for the small print, fellows, I've listed 4 cases, fellows, A, B, C, D. Your Lordship has already harmonized, approach the harmonizing approach. I'm sorry for the small print. One is Khajaman Waqf Estates Constitution Bench 1971. Second is Acharya Mahashri, Constitution Bench 1975. Devaru is there at page 247 in the relevant volume. And Adi Seva is there in Maras, a division bench in 2015, more recently. So, my lord is right. If your lordship will do me the favor of circling footnote 75, both in para 83 and in the bottom of the page. So, this is Malas the approach till now. My submission is there is no reason why lordship should revisit this approach. There is no reason to revisit it. Your lordship can give some more guidance on how to harmonize, and substantively all have to be protected. Otherwise, 25(1) is a very valuable right which can be attenuated and disappeared by applying a very overbroad approach on other provisions of this part. That's it.
But we have to also give some meaning to the word subject.
So, irreconcilable conflict, So, that or harmonization means that when you're a difficult corner, you have to override it.
26 is unhindered by the word subject to other.
That I've dealt with separately.
Whereas 25 is subject to other.
So, I am clear on this.
So we have to
Absolutely.
gradient difference.
So, one thing, I've dealt with 26 in a minute. I'm coming.
This anomaly,
25, your lordship will subordinate if it is irreconcilable conflict.
there is,
No doubt about it.
But when it
there is,
becomes-
in my view, there's no need for this. A simple reason. 25 deals with a person or persons. Incidentally, you can bring a religious denomination into this. But it is, when you said, you also need notes given, see, it's a collective belief of the persons concerned. As rightly noted by Sururmat also, it says we are not concerned with the place or other things and the temple or other things. We are only concerned with persons or individual person and their beliefs. So, 26 operates in a different field.
No, not 26, we're not 26.
No, we are telling you why. See, there's no, the subject matter 25 is only individual persons.
Correct.
And 26 is, it's only it is like some executant of a bill. When it's only a religious denomination consists of these persons only.
May I respond?
So what are its rights?
Yes.
How to administer? These are the things set in 26. There's no need to.
Let me.
Actually, 26 is an extension of 25. See, now I'll tell you why. If a religious denomination, if it acts against the belief, it can't do, because what is important is the belief which is protected 25 is the belief of the persons concerned. Religious denomination is only a recognized entity to give effect to the belief.
So much.
Yes, to preserve, give effect to, and then protect. If you appreciate this, there's no need to do this.
This 25 and 26 are very linked because the individual of
They're
25
because
forms the collectivity of 26.
that's what you're
There is
saying.
no 26
That's-
without the 25 collectivity.
Therefore, it is not something distinct or separate.
No, I am on a different one.
It's only manifestation. That's what we are saying.
Maybe I am not at the moment touching 26. So let me answer my lord. This is very important. It's important to clear this. We are at 25. I'm addressing a narrow issue, namely A, that 25 has to be interpreted in harmony with the generic fourth phrase. 2, the harmony means you must give enough weight to both so as not to reduce the 25 individuals' right to vanishing point. Number 3, however, we are not at 26, we're on 26. Forget 26 for a minute. I've dealt with it fully separately. Your lordship, so as Justice Bakshi put it, comes at a situation where the subject to other provisions, which is conspicuous by its absence in 26. So it has to be given a meaning stronger in 25 than it would in 26. It's not in 26 there. So 25 saying subject to other provisions, in a case of genuine irreconcilable conflict, where your lordship has bent over backwards to harmonize and cannot, then the individual's exercise will have to give way.
What I'm trying to
Will have to give way.
tell you is this.
Not in 26. You're not in 26.
A religious denomination has no existence because the persons involved there in that.
True, brothers.
That is, see, ultimately, it's only 26 deals about how to administer, manage, and other things only.
I'll tell Shiva.
So,
I-
that's exactly the reason why it was consciously thought not to replicate 25 into 26.
No, I'm saying, Manoj, we are now.
Except the subject to the provision, public order, morality, and then health.
So, Manoj, I am not only arguing at the moment 25, I'm not at 26. I'm only saying there may be cases where my individual right of 25 so irreconcilably violates 14. So irreconcilably violates maybe, Manoj, whatever, 19, some particular part of 19, where lordships can't harmonize. Then the framers clearly intended that 25 will give way to that. But Manoj, that's oversimplifying. Before you reach that genuine irreconcilable conflict stage, you have to strain yourself backwards to harmonize. That's the proposition I'm giving. 26, just leave aside. 26, I'm coming to in a minute. Obviously, you can't apply the same test to 26. That is the difference.
25
Ah.
is essentially with regard to equality of all religions.
Yes.
No religion is superior to the other. That is what is conferred. Persons are equally entitled to freedom of conscience. Ekam sat vipraha bahuda vadanti. The truth is one. But
Different
scholars-
people understand it different ways.
Scholars interpret it in different ways. That is why everybody is entitled to their conscience. That is expressed in 25:1. No conscience is superior to any other conscience. No path is superior to any other path. The goal is one, ekam sat.
That's
But
right.
the scholars take you in, scholars or gurus, whatever you may say, take you in different paths. You may follow any path you wish, your conscience.
You don't superimpose the validity of one path on the
That
other.
is expressed in 25:1. Everybody is got the equality.
So therefore, a person exercising his 20, and Manoj, we have this great
Not
tradition.
really part 3 as such there.
In Hinduism, we have this great tradition that people used to think earlier, Manoj, that the bhakti path is in some sense inferior to the gyan path, wisdom path. They said, no, each is a separate. So Mirabai's path of bhakti is of equal validity as the gyan path.
Yeah, Shaivites have Jnana
So-
and Vaishnava and that is Advaita. And Dvaitas go by the Bhakti Marga.
Bhakti path.
So it is different, but the truth is one.
One. So therefore, it's not that this is superimposed on that, it is better or worse. That's correct. I'm only saying a narrow thing. There could be cases where the exercise by an individual, which is 25:1, of his 25:1 right, which is to Manoj, profess, practice, and propagate religion, conflicts with 14, maybe with some part of 19, 19(1)(a), for example.
17.
And your lordship finds that after all your attempts, you cannot reconcile it. Then that's the question we're addressing. Then what do you do, Manoj? You have to give primacy to that phrase subject to, because the framers put it there after thinking, and they chose not to put it in 26. So Manoj, that's all I'm saying. That difference is there. But before you reach that end corner of being squashed in a corner as a judge, you will strain yourself very badly to harmonize, so that one is not reduced to manage. That's all I'm saying. The approach has to be that. Your lordship will have difficulty sometimes, but your lordship will have to manage that. Now, Manoj, page 70, para 85 is the. Well, 84, your lordship will put asterisk. It's a separate point. I'll come with it later. Rest I've left out. 84 will be under issue 3. Lordship will write on the side. Para 84 will be under issue 3. So I'm skipping. It's an interesting error in 11 judges by Justice Khare. Justice Khare Manoj misquotes and says this held so. Tilkayat and Dargah held so. That part of Tilkayat and Dargah nowhere held so. Can't be found. So that has spawned a progeny which your lordship should correct. It's 11 judges, but you can correct it because it is clearly not found. But that's the difference. But that's 84 will come in issue 3. Now come to Manoj 85.
We will read later on.
Later.
Because otherwise, very important and very
Yes,
important.
sir. That's why it's come a little up. It should come a little lower down. 85. The textual structure of each of the subclauses of 25, but then some typo is there, makes it clear. Kindly write it as makes it clear. I'm on para 85, page 70. I'm summarizing the textual structure point. makes it clear, that should be an S after make. 25.2 is not a head of derogation in the same sense as heads provided in 25.1. 25.2 is not drafted as a prohibitory or restrictive clause, but as a clarificatory and enabling one to permit and enable the state to make a law, either with various ancillary aspects of religious practice and or social welfare and reforms. Though the powers under 25.2, under both A and B, are undoubtedly wide to enable legislation to deal with ancillary and subsidiary activities, it cannot be reducing to vanishing point the basic right under 25.1. This is another part that within the same Article 25, you cannot use 25.1 or 2, 25.2 A or B to reduce one to vanishing point within the same article. Where is that addendum on MP and all? Where does it come? Where does it come? 89. Come to Sardar Sayedna at the next page, 71. 71. Justice Iyengar gives support to this point that you can't allow it to go to vanishing point. Just see the last 5 lines above the quotation. Pertinently, when evaluating legislation providing for social welfare and reform, the court must bear in mind, as Justice Iyengar said in his concurring opinion in Sardar Sayedna, that such legislative action must not be such as to reform a religion out of existence or identity. I'm sorry. Page 71, bang in the middle is a quotation, Malas. Above the quotation is 5 lines. So I'm quoting Malas.
You are reading D, clause D.
D, that's right.
And
but only the later part.
Before reproduction, 5 lines before that.
I'm grateful. Pertinently, when evaluating.
Pertinently when? You can say pertinently when.
Providing for social welfare and reform under 25.2b, the court must bear in mind, as stated by Justice Iyengar in his concurring opinion in Sardar Sayedna, that such legislative action must not be such as to reform a religion out of existence or identity. In my view, by the phrase laws providing for social welfare and reform, it was not intended to enable the legislature to reform religion out of existence or identity. Just as the activities referred to in 25A are not of the essence of religion, similarly, the saving in 25.2b is not intended to cover the basic essentials of the creed of a religion, which is protected by 25. This is why there is one external 25, as I was rising, 5 seconds. 25.1 is one under threat under subject to other provisions of this part that I've dealt with. The second possible threat is, I'm using the word threat in a different way, under 25.2a and b. This is internal to 25, in the architecture of 25 itself. Now, this clause which Justice Iyengar has said cautions you that yes, you please do all the reform, please do it, but you do not interpret in a way that the religion can go out of existence or identity. That will not normally happen, but the test is here. The test is here. As I'll continue. Time.
No, we said we'll continue at 2.
Oh, yes. Oh, I was scared you were asking a different question.
No, we just want to know that how much approximately.
Well, I will take the good part of the balance a little bit earlier. I'll Now your lordships have reached issue 2 at page 73. If my lords will do me the kindness of writing at page 73, above para 90, paras 89-89A-89E. You should just write there, C addendum B. Well, it's before 90. The very important question here is of interplay of 25 and 26. The questions my lord asked me earlier, and I said I'm dealing with it here. So the heading of issue 2 is at page 73 of my main submissions. What is the interplay between the rights of persons under 25 and the rights of denominations under 26? So before 90, which is the first para here, kindly say, Manas, insert 89 capital A to 89 capital E, which is the corrigendum addendum B, those paras, which we gave in the morning.
Page 4 of it.
So addendum A was Seshamal. In the same corrigendum, addendum B at page 4 is these paras. At page 4 of the corrigendum.
You want us to read first 89 and then 89A or 89A?
No, from 90, it will start from 89A to 89E, which is the addendum. You will start issue 2
That is
with
also
89A, correct. So my lord has seen the heading, that is the interplay of 25 and 26. And therefore, Maharaj, there is no question, as Justice Sundaresh said, they are obviously linked. They can't be dealing. One is individual, religion, man and God. Second is collectivity, religious. So therefore, they are linked. Now, these propositions are clear. Now, the 25(2)b has two parts. It was believed that you could read one ejusdem generis to the other. I'm not arguing that. The second part of 25(2)b, Lordship can glance at it, reads, open it, which I'm dealing with first, reads, throwing, give me a second. Come on here. Throwing open.
Of Hindu religious institutions.
So, your Lordship will start with the word or. Forget the first 5 words. Or the throwing open of Hindu religious institutions of a public character to all classes and sections of Hindus. On this addendum is dictated. On these words. According to me, they deal entirely and exclusively with entry and access. And therefore, harmonization I am doing of this with 26, which is a Lordship's query about issue 2, by saying that all entry and access issues would be governed by 25(2)b. Once you enter and have access, 26 bracket B takes over. That's in one line my submission. Now kindly read with me the addendum. Article 25(2)b, throwing open of Hindu religious institution of public character, must necessarily govern finally and conclusively on the issue of entry. The dispositive word is entry. The word entry is used in the sense of the entry into the main gate of the Hindu public religious institution and also its compound. This cannot be extended to subsume entry into the inner sanctum sanctorum of such institution. 3. C. Having once exercised the right of entry and not being liable to exclusion at the entry point by any rules, practice or custom of the Hindu religious institution, 26(b) would necessarily take over within the precincts of such an institution. That's number 3. So there is a system, there's a method to the madness, and a Lordship with 9 judges can clearly harmonize. That's my attempt. In any event, none of the entrants can assert an individual religious right under 25(1), that is the main one, to insist on conducting worship or seva within the sanctum sanctorum, since that must necessarily be governed by the collective rules and practices of the institution denomination under 26(b). Consequently, all other rules, practices and customs operable within the precincts of a Hindu religious institution of a public character must be observed by all the entrants who have already entered under 25(2)b. Hence, for example, wearing of shorts may be disallowed in some cases and covering the head of females may be mandated in other cases. We know all the examples, so many examples are there. It is submitted that this reasonably harmonizes 25(2)b and 26(b), It does not reduce either to vanishing point. It gives content and meaning both to social reform intended to abolish entry restrictions based on caste, class, etc., while preserving significant rights to the denomination concerned, quote unquote, to manage its own affairs in matters of religion. G. Now this is interesting. All what I've said will not apply to a private temple, but a private temple properly so defined, not as I would like to define it. All of the above, including 25(2)(b, would be disapplied and inapplicable in the case of a private temple or private religious institution. Several judgments have defined and described the contours of what constitutes a public temple versus a private temple. Malas, one or two of these, the Goswami I would like to read, Malas, in a minute. And the last para, and this Parasamaya Malas, follows Goswami. Even supposedly small temples, this is not size specific, Malas. Even supposedly small temples can be religious institutions of a public character, based on long usage by the public on account of faith, custom, and practice. Again, this Goswami Mills, and another case called Bala Shankar. Let me just finish this addendum. To the aforesaid extent, this addendum disagrees with the stand canvassed by Learned Counsel for the NSS, that is Mr. Vaidyanathan. It is significant. Now, I'm on the second part of this, on the debates, on this part, on this issue. The CAD debates unequivocally intended to make a sharp distinction between the restrictions consciously put in 25 as opposed to the structure of present day 26, which appears to be consciously subjected to fewer restrictions. The point Mrs. Bakshi also made before lunch was. This is evident from the fact that in Article 20, which is the precursor of 26, 19 was 25 and 20 was 26. A specific amendment was moved and negatived on 7th of December 1948. Dr. Ambedkar said, in the beginning of the Article 20, the words subject to public order, morality and health be inserted. That is in 26. Mr. Ahmed moved an amendment saying that Article 20 be renumbered as Clause 1 and the following new clause be added. Nothing in Clause 1 of this article shall affect the operation of any existing law or prevent the state from making any law for ensuring public order. This is a very, very important clue, Malas. Look at the width of this one. This would have given the state a power. And the formulation Mr. Ahmed moved was prevent the state from making any law. Nothing will prevent. This was negative. Dr. Ambedkar's formulation remained. Of course, secondly, Malas, he also wanted two words public to be added. He said morality should also be public morality, not morality, and health should be also public health. According to me, Malas, the word public before then brings it something of an external objective test. Whereas the deletion of the word public, which is what happened when Mr. Ahmed was not accepted, his amendment was negative. It means, Malas, it's a more subjective test. Anyway, the last line, negative. So, Malas, a specific amendment giving or disapplying and allowing the state to make any law was a negative amendment. Now, this takes care of my submissions. Just see Goswami for a minute, Malas. Where do you get it? Malas, we have filed additional case law compilation, volume 13. I am minimizing it. This lordship will be profited by seeing the public-private disc. Volume 13 we have given, volume V.3. What is the volume number? 6.2? Yes. Why do you say 13? V 6.2. Number is not. And this is why. What your lordship has got is right.
Page 54.
At page
54 onwards, last paragraph.
keep on nuancing it.
Last.
Come to the end of page 54. On the top, the page is given. We are not discussing public and private temples, but this is useful to know, Malas, that when you go into temples, you just don't call anything private temple by calling it private temple. Very nice test is given here. This will be followed by everybody else. How many judges? How many judges? 3. Sure.
How do you explain the word public character?
That is precisely what this does. A temple, by long usage, antiquity, fame, veneration, of whatever size, may even have started as a private,
Public.
may have started as a private. By a combination of these factors, very interesting coming here just now in this para, can have become an institution of a public character. In fact, one of the tests is very important one, very interesting. Built in such an imposing manner. See the test is very nicely put there. Kindly read this test.
Paragraph?
Page 54, bottom. It's a 1970 judgment which is followed by all the public private issues, Malus.
Yes.
At H, Malus, the placetum is H. This is Virale has got it. Yes. May I read, Malus?
Though most of
Though most of the present day Hindu public temples have been found as public temples, there are instances of private temples becoming public temples in course of time. Some of the private temples have acquired a great deal of religious reputation, either because of the eminence of its founder or because of other circumstances. This will answer, I believe, Justice Sundaresh's queries. They have attracted a large number of devotees. Gradually, in course of time, they have become public temples. Public temples are generally built or raised by the public and the deity installed to enable the members of the public or a section thereof to offer worship. In such a case, the temple would clearly be a public temple. If a temple is proved to have originated as a public temple, nothing more is necessary to be proved to show that it is a public temple. But if a temple is proved to have originated as a private temple, or its origin is unknown or lost in antiquity, then there must be proof to show that it is being used as a public temple. So that's what determines its public character. In such cases, the true character of the particular temple is decided on the basis of various circumstances. Very interesting. See, number one, is the temple built in such an imposing manner that it may appear prima facie to be a public temple? Are the members of the public entitled to worship in that temple as of right? Are the temple expenses met from contributions made by the public? Whether the sevas and utsavs conducted in the temple are those usually conducted in public temples? Have the management as well as the devotees been treating that temple as a public temple? Then when they go on regular worshipping, just read a few lines and I'll not read more. From F, the circumstance that the public or a section thereof have been regularly worshipping in the temple as a matter of course, and they can take part in the festivals and ceremonies conducted in the temple apparently as a matter of right, is a strong piece of evidence to establish the public character of the temple. If voting offerings are being made by the public in the usual course, and if the expenses of the temple are met by public contribution, it is safe to presume that the temple in question is a public temple. In brief, the origin of the temple, the manner in which its affairs are managed, the nature and extent of gifts received by it, rights exercised by the devotees in regard to worship therein, the consciousness of the manager and the consciousness of the devotees themselves as to the public character of the temple are factors that go to establish whether a temple is a public temple or a private temple. And the other two cases I'll give in my addendum follow this case, Bala and the Parsamaya. Not necessary to read it. Now remains a difficult part, which I'm not answering in the addendum. You should have to take notes on this. The first 5 words of 25(2)(b). So the easy way is to say that it is colored by the later words. And this is a similar, that's not right words. These were independent words and separated by a conjunction called and. The first 5 words are independent words. They are not, I mean, I would like to limit it to access and entry, but that's not fair. You can't. They are meant to allow social reform, and the obvious example is number of wives, for example. Some kind of succession law, some kind of family law, some kind of personal law. So now, Millets, the best harmonization of this can be done only by saying that you cannot use the first 5 words to take away 25(1) out of identity, recognition, or existence. You cannot use this dehors public order. Now, question is usually put, but I'm anticipating myself and answering. That if you say that this is so, how does sati get abolished? Well, sati gets abolished in any case because of public order, to which 25(1) is subject. You cannot apply another standard now of a very general kind. But yes, you can reform Hindu religion, which may have some very bad practices considered by contemporary standards bad. Example is 4 wives, 3 wives, etc., which was done by the 1956 amendments. Now, Mullahs, in that, there is a very nice para in Mullahs, which one? Sardar Sayyidna. Your Lordship may have to do that favor to me to again go to Sardar Sayyidna, which is, what is the volume?
Volume 3.1.
Volume V.1. Mullahs, before that, I'm sorry. Just come to Mullahs, page 41 of my written submission, which is page 41?
71.
Page 71. 71 of my written submissions. So one part of Sardar Sayyidna I fortunately quoted. So Lordship doesn't have to go anywhere. Come to page 71. This dealt with the first 5 words, which I am now pointing out. So Sayyidna Mullahs, I believe is valid law for this point, and your Lordship may usefully, Mullahs, consider adopting this formulation on this point.
Paragraph?
Mullahs, page 71, my Lord has read it, but
Yes.
now I must emphasize.
Yes,
Pertinently, about 10 lines from the top.
yes.
Pertinently, when evaluating legislator providing for social welfare and reform, that's 25(2)(b), opening words.
Yes.
Under 25(2)(b), the court must bear in mind, as stated by Justice Iyengar in his concurring, that such action must be such as to not be such as to reform a religion out of existence or identity. In my view, by the phrase laws providing for social welfare and reform, the first 5 words, it was not intended to enable the legislature to reform a religion out of existence or identity. Just as the activity, the middle part is not relevant, I've skipped some lines. Just as the activities referred to in A are obviously not of the essence of religion, that is the Lordship secular activities. Similarly, the saving in B is not intended to cover the basic essentials of the creed of a religion, which is protected by 25(1). So, your Lordships, I would submit with great respect, the 9 judges should not leave these 4 words, cover the basic essentials of the creed of a religion. Otherwise, your Lordship will be allowing the first 5 words of 25(2)(b) to swallow up 25(1), which
Interestingly, by doing that, you are bringing in the expression that there will be some tenets or some practices, essential and integral, and some non-essential and directorial.
I am aware. That's my next point. I am aware of the word essentials as kept in here. Remember, this is the Dargah judgment which brought in essentials. So therefore, this word is there. I am not on essentials. I made my arguments fully on essentials.
From Tirupati.
I beg your pardon? No, the main judgment was Dargah, which we put it very clearly. We put it clearly. Your Lordship knows that. So I cannot improve on what I've said pre-lunch on essentials. This one I'm citing specifically for 25(2)(b).
So
Now,
there will be
yeah.
a degree of judicial evaluation
Yeah,
of
yes.
essentiality when it tests any legislation under 2B against a religious practice sought to be
No,
propounded
so
by
therefore,
a
Mullahs,
religious
I would,
denomination.
therefore, Mullahs, I would, yes, correct, my Lord is right. I mean, I can't run away from essential used here. The answer is this, Mullahs. You will have to
Either you have to adopt Mr. Vaidyanathan and say, whole
No, I'm opposing.
lock, stock, barrel, 26B
No.
is dealing.
No, I cannot say that.
If not, then you
Much as I would like to, I cannot say that.
fly in the face of
So-
essentiality
so-
being a relevant test.
So clearly, second part of 25(2)(b), I'm disagreeing with my learned friend with greatest humility and respect. And entry apart 26(b) of
I was first saying
second.
25 to A.
Yeah.
Your point is very well taken. Any religious practice is completely distinct from secular economic.
That part is over, Mullahs. That's all. That's all.
Practices associated
Correct,
with the religion.
correct.
But when it comes to
No,
2B,
therefore, Mullahs.
and reform this legislation is made,
Yeah.
essentiality to show that whether the religion itself becomes effaced will be a relevant test
Well,
to see whether the judicial, the legislative.
These are the
interventions-
creases which 9 judges can, should, and must clean up. Essential word has come, no doubt. That's what Dargah is known for. Your Lordship can maintain the rest of this para without using the word essential. Allow me to explain. And should not allow the word essential to come in. So firstly, please.
Why did they use this word, say? Why did they use social welfare and social reform instead of public order, health and morality?
Therefore, Mullahs,
What's the reason behind this?
Yes, I'll tell you. certain practices, even by an objective standard, which would not be upheld, though they were religious practice. The best example is multiple marriages. That's the best example because you can't immediately say, now it is possible. It is possible.
Even
to it.
various forms of marriages, Sapinda marriage.
Yeah.
The
Relationship.
So-
law restricts them. Or marriages within prohibited relationships.
Yes.
Of 5 generations or 3 generations
Yeah.
from the matrilineal or patrilineal side. Now, if someone challenges, it would be said to be a reform, which is not changing the core tenets of the core practices of the particular religion. And in this situation,
Somewhere essentials will come in through the back door.
a core,
back door.
sir, whether we use the word essential, whether we use the word integral, whether we use the word, let us say,
Concept will be there.
Borrowing from the constitutionalism as basic structure of the religion, whatever it
understand.
may be, there will be a variation in some religious practices against inalienable religious
I
practices.
see entirely the point made. So let me try and harmonize. But it's very clear.
This is nothing but
Would you contest the word inalienable religious practice?
My Lord is.
Practice which
This is my Lord.
alienated from the religion.
This is my
changes
Lord.
the
This
religion.
is my Lord's third synonym for essentiality.
Essentials of the creed.
After 2 earlier synonyms for us. So let me explain. This is a very important. This is ultimately will have to be a lordship's subjective judgment to some extent. I mean, there is no clear answer. There is no doubt that Dargah has gone down that path. I mean, I can't deny that. So let me just try and harmonize. So whatever I'm saying now is about 2B, first 5 words, and not about 2A, and not about anything else. That's first. And on 2B, second part, I'm very clear. Entry and access, I made my points in the addendum. So this is without. On essentiality, I'm equally clear. I made it pre-lunch. I stick to that. Now, let's, on this one harmonization is that if your lordships can clarify this para of Dargah, minus the essentiality. Sorry, not Sardar Sayyidna, not Dargah. Sorry, Sardar Sayyidna. My apologies. Now, that's ultimately a subjective judgment of your lordship. That's why lordship is a 9-judge bench. I mean, why is the lordship sitting otherwise? If your lordship had to only reiterate, fortunately, your lordship is not.
that will be bit too dangerous for us to do so.
No, so therefore, let me say why it's not dangerous.
Read it in such a negative way and then say that it will, notwithstanding the existence of a social reform.
Yes. No, I'm not
Social
saying that.
welfare.
I'm saying
It has to
fully.
yield. See, whatever religious practice, I believe, will have to yield to that.
Well,
That's a simple
I am
interpretation of
fully preserving, contrary to Mr.
what constitutes,
Vedanath.
what is the role to be played by the court, and then that's a different issue.
So, with great respect to Mr. Vedanath, unlike his argument, I am preserving
Ah,
both the
that's it.
second part and I'm now preserving the first part also. I'm not decimating it.
That's that bit.
But I have to, it's my duty to try to clarify. Now, I can only clarify by saying that the core of this Sayyadna judgment should be maintained, but there are words available to lordships to do it without saying that 9 judges are upheld essentiality test.
Yeah,
That's
but
one answer.
What my brother is saying otherwise is this: leave alone essentiality and
Yes,
whatever
yes,
Raman said
yes.
there. When it comes to an element of social
please.
welfare or social reform,
Ah.
that is the consideration for the government and for the state and also for the court. That's what my brother is
There
saying.
is no quibble on
To
this.
that extent, we cannot either trace it under public order, morality or something like that.
It is my case
Yes, yes.
that social reform and welfare
Yes.
must be allowed, contrary to the other, my learned friends earlier, and the first 5 words must be given meaning. But I have to now explain.
An example we given about the Succession Act. It's a social reform.
I think again it will depend on case to
Case to case basis.
That is one answer.
That's correct, exactly.
What we can, while the social welfare reform are preserved by the constitution,
Yeah.
in the name of social welfare may not be preserved.
That's one. That's clearly one. Now, I must go further. I believe there is harmonization possible.
In the
Why?
name of,
Let me explain how.
in the name of social welfare
You cannot,
and reform,
out of
you
identity
cannot
existence.
follow out the religion.
That's the point. So, you are deciding whether social reform maintains the religion or converts it into non-religion. But not that social reform is doing essentiality or non-essentiality. Now, allow me, Melis. There is one part.
What Melody said is that to understand the social welfare or the social reform, you have to go to the constitution, especially the part 3, to understand this.
Of course.
For example, 14 or 15 or anything else there.
Absolutely.
To that extent, we can. To extent, the court can go into.
Now, so this one part of
And
Sayyada,
second part can be an illustration.
yeah,
The second part of the clause B is an illustration of social reform.
which is very specific, which
Yes,
models
it's an
is
illustration
the
of that.
so the little difference.
Specific.
The little difference is specific to classes, caste, exclusion, 17, Dalits, all that, the whole
So
program.
many types
So
of
many types.
reform, it is one thing which is specifically put because it was so glaring.
Correct, so glaring, and
So
so much
glaring.
anathema to a young nascent republic with constitutional values, absolutely right.
And it is confined to the Hindu religious institution.
Only.
We only expand. May not even confined to a religious denomination also.
Yes.
What
Now,
is, that's why it only says Hindu religious institution
so my
of
submission,
public character.
in a nutshell, my submission on this is: one, it has to be a case by case irony. Two, when a lordship is laying down the law, according to me, it is entirely possible to lay down the law, saying that you cannot take it out of existence, recognition, or hollow out, as a lordship said, without using the essentiality test.
Yes.
That's what I'm trying to say. Third, there is one part of Sayyada which we have unfortunately not quoted. If your lordship will just come just a little below the same page, that is 349 of V.1. 349 of V.1. Unfortunately, it's missed out in the quotation, just 5 lines, which has the same sentiment. So I am always exhorting the Honorable 9-Judge bench to adopt this principle minus any reference to essentiality, and those words are possible to be done. It's only a question of using the words. V.5.1, volume 5.1, Roman 5.1, page 349. Right at the bottom, just where the case ends.
All.
What your lordship read was above on 349, which I have quoted.
Yes.
I did not quote the last few lines of 349. Justice Amanullah has it. 349 bottom. Volume V1, V.1.
Volume 1, is it?
Yes.
V.1.
Volume V.1, Wallace.
Someone will say.
It's on that screen, Wallace. It's right there. This, just take the page down.
How does the para begin?
That's right, I want to mark it.
Coming back to the facts of the present petition.
Volume 3.
Wait,
Just put that stuff.
one page earlier.
Yeah, just coming back. Yeah, that's
what-
right. No, please don't go down. Sir,
No,
please go up.
there only.
Yeah,
Coming back to the fact.
Now, Wallace, what I have just quoted is the previous para, which I have quoted. Somehow this few lines got left out. If your lordship goes to the end of this coming back para, bottom of the same page. Please stop, please stop. Last 5 lines.
This is judgment entered by
I beg your pardon?
The power of excommunication.
Yes.
you already which judgment?
For the purpose of ensuring the preservation is therefore of prime significance.
What is the judgment you are referring to?
Sayyadna.
Okay.
Sayyadna. The first Sayyadna judgment.
Yes.
The 7 lines. The power of excommunication for the purpose of ensuring the preservation of the community has therefore a prime significance in the religious life of every member of the group. A legislation which penalizes this power, even when exercised for the purpose above indicated, even when that is for social reform, the legislation for social reform, cannot be sustained as a measure of social welfare or social reform without eviscerating the guarantee under 25(1) and rendering the protection illusory. Your lordship may use hollow, your lordship may use negatory, your lordship may say eviscerating. This sentiment is clear, and I believe your lordships can do this sentiment without the essentiality error, which I believe.
In this case, the Prevention of Excommunication Act was upheld.
Yes.
It was upheld.
Yes, petition allowed.
No. See, the act, excommunication was to be prevented by this.
No, the act, I believe, abolished it.
No.
Check the act. It says petition allowed.
Prevention of excommunication, correct? But the Supreme Court upheld it. That means there can be excommunication.
That's right. That's what I'm saying. Correct. That's why this issue arises, brothers. Excommunication by an objective standard is considered anti-social reform or anti-whatever, welfare. Somebody files one of the petition. Your lordship upholds it saying that it is,
The reformist law was that excommunication is illegal.
correct,
The Supreme Court set it aside, saying that it is violative of
of the
Article
25(1). That's all I'm saying. And the test is, you are eviscerating, or as my lord said, hollowing out the religion itself. Now, in a sense, it is correct on semantics that you are eviscerating or hollowing out can also be the essential part of it is excommunication. You are taking away the essential part. That's the way of formulating it. But your lordship can easily correct it. Your lordship can say that something which renders the religion hollow or renders it illusory is not to be allowed.
There's a
Without going
difference
into
as
deciding whether it is essential or not essential. That's what I'm saying. Now, now I should be done with my addendum. Come to my main submission.
74.
Page 74, para 94.
Yes.
So this, I have harmonized to the best of my ability both parts of 25(2)(b).
Paragraph 94.
Yes, page 74. These are my entire submission on 25(2)(b). The rights guaranteed under 25 and 26 came up for consideration before the court in several cases. I'm reading para 94 at page 74 of my main written submissions. The rights guaranteed under 25 and 26 came up for consideration before the court in several cases, and the main principles underlying these provisions is that the protection of these articles is not limited to matters of doctrine or belief, but they also extend to acts done in pursuance of religion, and therefore contain a guarantee for rituals and observances, ceremonies and modes of worship, which are integral parts. Now, that's true. This word integral is used again. That's the same three judgments, Shurur Mat. But I've explained that, but I don't want to repeat it. You have to understand the way in which I would like to read it.
97.
Now come to para 97
It's 75.
at page 75. I am scrupulously trying to read only those paras which have not been covered at all. Upholding the autonomy of religious denomination under 26, it was further held, because this issue too is about interplay of 25 and 26. So I'm touching on 26, although the main 26 will come a little later. Upholding the autonomy of religious institution, it was held. In Shirur Mat, 7 judges. Under 26b, therefore, a religious denomination or organization enjoys complete autonomy in the matter of deciding as to what rites and ceremonies are essential according to the tenets of the religion they hold, and no outside authority has any jurisdiction to interfere with their decision in such matters. It should be noticed, however, that under 26d, it is the fundamental right of a religious denomination or its representative to administer its properties in accordance with law. And the law, therefore, must leave the right of administration to the religious denomination itself, subject to such restrictions and regulations it might choose to impose. A law which takes away the right of administration from the hands of a religious denomination altogether and vests it in any other authority would amount to a violation of 26(d).
I think
Then was Ratilal at para 99, 3 paras later,
3 days.
3 days after Shirur Mat. The language of the two clauses B and D of 26 would at once bring out the difference between the two. In regard to affairs in matters of religion, the right of management given to a religious body is a guaranteed fundamental right, which no legislation can take away. On the other hand, as regards administration of property, which a religious denomination is entitled to own and acquire, it has undoubtedly the right to administer such property, but only in accordance with law. So these are the interplays. Your Lordship's question is interplay, 25 and 26. A law which takes away the right of administration altogether from the religious denomination and vests it in any other or secular authority would amount to violation of the right which is guaranteed by 26d, same point as the previous paragraphs. It is noteworthy that in Devaru, the issue decided was whether the right of a religious denomination to manage its own affairs in matters of religion guaranteed under 26b is subject to and can be controlled by 25b, 2b. That is throwing open. I've already made my addendum on this, fellows. Throwing open I made, but I'll just read through it quickly. I've already covered it. This honorable court held that if 26b alone is applied, then any provision of the Madras Temple Entry Authorization Act throwing open access to all classes would be unconstitutional creating an apparent conflict between B and 25(2)(b). Now, this is where we differ from Mr. Vaidyanathan, because he went whole hog. He has a point of view, we will have to consider it. All arguments as to why 26(b) should override 25(2)(b) were rejected. The principle of harmonious construction is pressed into service. It was held in footnote 100, the page is given, that while for all matters 26(b) will apply, regarding entry into a temple, 25(2)(b) will apply. I think this harmonizes adequately, and we don't need to go into a head-on collision.
Page 78.
103, page 7.
This is the harmonization which I have expanded in my addendum, which your worship has read. Then para 103 at page 78. This is a more recent division bench, Adi Seva, 103, broadening the limitations under 26. Where is it gone? Sorry.
I'll do this, you can use.
Give a minute, please. Yes. Besides the freedom of religion being subject to other provisions of Part 3, undoubtedly Articles 25 and 26 have to be harmoniously construed with the other provisions contained in Part 3. Now, this is not strictly correct, but this is the meaning of harmonization. So I conclude at 106 with my summary. 106 is the para number, page is 78. Again, at the end of each section, I've given a nutshell summary of this. Denominations and even sections thereof, understood in the widest possible sense, are protected under 26. Management of affairs of denominations or sections thereof cannot be diluted or deprived by the legislature, which, however, can regulate administration of property associated with religion and religious practices. In case of a conflict between an individual right under 25(1) and the right of a denomination under 26, the right of the denomination would prevail, as Article 25(1) is subject to other provisions of Part 3, which includes 26. Other provision we forget, but it includes 26 also. Other provisions will include 26 also.
Yes.
So that we have to remember.
Even
No laws.
25(2).
Huh?
Even 25(2).
Yes, yes. No, but I'm saying, the next article also is other provisions. That's all I'm saying. No laws under 25(2)(b) facially appear to violate 26(b). This is the harmonization. Harmonious construction is the only methodology available to give some meaning and scope. That is entry versus non-entry. I made that point. Such harmony is arrived at by allowing 26(b) untrammeled supremacy regarding all other forms of religion and religious practice, but by creating a carve-out when a law under 25(2)(b) will prevail if it seeks mandate of access or social reform in certain situations. Even the latter carve-out in favor of 25(2)(b) is subject to the further limitations imposable by Article 26(b). Now, this is interesting. The access is to the compound and to the entry, not to the innermost sanctum sanctorum, would still be protected by 26(b). That is my para F. G, a law is an essential sine qua non to begin to intrude. Then 14 and 15 laws will have to reconcile. J, 25(2)(a) does not permit the state to regulate religious practices themselves, but only economic, commercial, or political activities that are associated with religious practices, as clarified in Schedule 1. The freedom to practice under 25(1) therefore remains protected, except when they conflict with public order, health, or morality.
Your
Now-
clause F, this paragraph F, small f,
Yes.
is almost identical to Mr. Vaidyanathan's argument.
No. Mr. Vaidyanathan says that your 25(2)(b) has to give way even to 26(b), even to the extent of entry.
No, I don't think he meant that.
I hope not. That is good, but I don't know. I understood that to mean that.
See, one other way of looking at it is this 25(2)(b) is with regard to social reform. Social reform is different from religious reform.
But there are 25(2)(b) has two parts. One is social reform and welfare. One is entry.
Entry is one.
So the two parts.
That has.
Yes.
No, the first 5 words. It is not religious reform.
Yes.
Law cannot be made for religious reform. Law can be made for social reform
So that we have dealt with, Manoj.
in religious institutions.
So that I've dealt with Sayyidna, I just finished that. I was saying that to my
There
understanding,
can be no
I'll
apprehension.
be very happy if I'm wrong. On the second part of 25(2)(b), second part, I understood Mr. Vedanta to suggest that even entry restriction will be controlled ultimately by the rules of the denomination. If I'm wrong, well, it's very good because then he and I are the same then.
By saying Venkatramana Devaru is wrongly decided.
Yes. So, therefore, Manoj, I'm only, I was sitting here, I heard it.
It's a matter of degree.
Huh?
It's a matter of degree. You're saying
maybe
they
we'll-
can enter, all classes can enter, but
No, well,
not to the.
That may constitute more than a
Sanctum
matter of degree.
sanctorum.
It would be a substantive difference.
Yes.
A law will say you are authorized to enter and the precincts, whereas the 26(b) rule may say you cannot enter. So there will be direct conflict. Where your lordship will have to decide 25(2)(b) governs on the second part. That I'm very clear on that. And in fact, as your lordship knows, Rajkumari Amrit Kaur, what's the other lady? Lakshmi Maitra, the three ladies, all of them insisted on this. There was no clause like this. The founding mothers insisted on this. And they
Renukare,
it's all getting into an extreme form of discrimination and petty practices. What is all this?
KJTS was the institution of a public character.
I beg your pardon?
The requirement is it should be an institution of public character.
Yes.
Once you put it into a public character, then the state is empowered to do it.
Override.
To the extent, whatever the right you can trace in 26,
That is overriding.
26 also.
None of what I'm
subject to that right only.
none of what I'm saying can apply to a private.
That's correct, that's correct.
Obviously not. Now we come to issue 3.
Yes.
Okay.
Ah.
K has been read here so many times.
Family temple, communal temple, communal temple, where family temple is there. That you can, because it's not public character. Private temple. Yes, it will apply only for public character.
Not necessary. It's repetition. K and L also is there. It's somewhat repetition. I'll not read it. Now, your lordship comes to issue 3. So, issue 3 is similar to my 1E, but 1E was on Article 25. This is on 26. So, it's significantly different. Issue 3 sounds similar to my first issue, capital E.
That's it.
But that is not overlapping because this is 26. That was 25. So the issue is whether the rights of religious...
That was put under 25, this is 26.
Yes. I beg pardon?
That was 25.
Yeah, this is 26. That's correct. Whether the rights of religious denominations under Article 26 are subject to other provisions of Part 3 apart from. This is a very important question. Are subject to other provisions. Now we are in 26. There is no dispute on 25. It is evident from the language of the opening sentence of 26, in contrast, that 26 has not, that not should be in capital letters, been made subject to other provisions of Part 3. Unlike 25, an analysis of the debates would reveal that the framers had consciously and intentionally not made 26 subject to the other provisions. Now, Mills, next page, 81. It quotes on the top the original Article 25, which was then Article 19. And then it quotes Article 20, which is now 26. So both 19 and 20 were draft articles next to each other. One had subject to other provision, one did not have. I hope I'm clear. Right in the beginning, in the inception. Then one was 110. On 7th December 1948, draft Article 20, which is now 26, was moved for adoption. Dr. Ambedkar moves this amendment. In the beginning of 20, the word subject to public order, morality and health be inserted. Now, he knew that the previous article says other provisions. Dr. Ambedkar obviously knew that. He chose not to put it here in Article 20. Then, Your Lordship will come to 112. Although this omission was sought to be remedied, the words subject to public order and morality and health were duly added in 26. The phrase other provision of this part was consciously left out. Consequently, the unequivocal intention of the framers was to not make 20, now 26, subject to other provisions. Tell me anything I miss out. Don't listen to the important. Para 114.
Oh, I'll ask a small question. Question.
Certainly.
What is a religious denomination? How does it how is it constituted? Religious denomination is it's a bunch of group of believers.
Collectivity.
Right? So, as against the believers, Article 25 will apply, including 25 2. Apply or not? Will it apply or not?
2 will apply.
Apply.
But
then if you apply Article 25 to them, how do you say it not apply to the denomination? After all, denomination has its life and existence because of the belief, collective belief, as you said, of those persons who gave it to them for protection and preservation.
So we're back to the same.
We're only telling you.
Yes, correct. No, I'm not saying that.
No, how do you apply the law?
Yes, straight away.
If a law, can it apply to the members and then I say it not apply to them?
No.
It is not no independent existence otherwise.
Your lordship will now put on the left column 25 2B.
Yes.
On the right column 26B. That's the issue I believe my lord is raising. Left column 25 2B.
They are trying to see it differently. That's a problem.
No,
what I'm trying to tell you is this.
Yes.
Consciously, the Constitution does not refer to subject to the other part, because it goes without saying that what is in 25 will apply 26 also. Otherwise, it doesn't make any sense. You can say it will apply to A person, it will apply to B, C, D, E, but does not apply to the religious denomination created by them.
So can I answer?
It doesn't.
Please. Can I answer?
Yes.
is state's powers.
Please proceed.
Left column is 25 2B. Right column is 26B. Now, answer number 1. On entry, I have already argued in great detail the second part of 25 2B, that it will prevail over 26B. Crystal clear, there's no doubt about it. Whether I am at variance with Mr. Vaidyanathan or not, I don't know. My argument is clear. I believe Mr. Vaidyanathan took a different line. Second answer. On the first 5 words of 26 2B, 25 2B, if you make a law for social reform, which does not eviscerate or hollow out the religion, then that will also prevail over 26B. I hope I can't be clearer than that. Again, refer Sayyadna and the other judgments. Answer number 3. If your lordship were to go further and say that other provisions of this part not put in 26B or 26 is implicit in 26, then I would say your lordship would be wrong. It is not at all implicit in 26. 26 is consciously freed from the fetters of other provisions of this part, which means the gamut of 14 to 30 or 32 minus what is put inside. So there are 3 clear answers.
So that means 25 2B has to be only with the object of maintaining public order, morality and health. With that object in mind.
No, yes, that is one.
Because that is in both.
No, that's clear. That's clearly because that's in both. My lord, that doesn't require discussion. Further, 26B is subject to, further, in addition. So 3 is those. Fourthly, 26B is subject to law throwing open of Hindu religious institution of a public character to all classes. That also 26B will be subordinated to 26B.
25.
6B is subject to 20.
The second part of 25 2B. Now, fifth, it may also be subject to the first 5 words of 25(2)(b), provided the legal reform or social welfare reform does not eviscerate or hollow out the religion out of existence or identity in 26(b).
That we appreciate.
These are 5 very clear propositions, Wallace.
That seems to be correct.
Last one we have.
That's it.
That means
Now,
Venkatramana Devaru is rightly decided.
Wallace,
According to you.
to the extent of my Wallace submission, yes. Now, in this, if you argue, I am not arguing it. If you argue that 26(b) will prevail over the second part of 25(2)(b), I at least don't agree. If you argue that 26(b) will prevail over the first 5 words of 25(2)(b), I don't agree. But what is subject to my caveats?
So that is
I understood
harmonizing.
the argument.
Yes.
I'm grateful for the query.
All right, thank
More
you.
clearly, Wallace.
Thank you.
Sometimes this helps to clarify. Now, 114 at page 82. A search through the debates does not reveal any analytical discussion as to why the phrase subject to the other provisions was inserted in 25 and omitted from 26. So there's no reason I can say. I mean, it is very clear why, but I mean, there's no reason given in the oralizing. Though at some places of debate, there is some speaker refer to the phrase subject to the other provisions. It has, however, been noted by the Supreme Court on more than one occasion. This is one of the number of cases in my footnote 110, including the Sabarimala case itself. It's obvious textually that difference has been noted by our lordships in many, many places. In my footnote 110, I'll skip it. Now 115. Where is TMI? After which para? Why do you say this? In the case of freedom to manage religious affairs is contributed in 26, and in particular in Article 26(b). It is legitimate to go even further and state that in cases of inevitable conflict between 14 and 26, it is the latter which should prevail and not the former, on the following twin principles. 26 is a specific narrow special carve out for specific purposes, whereas 14 opens with part 3 and general, whereas I would withdraw this para 115. I put it there on reflection, or should I cut it off? I am not pressing this. My overall argument remains that you have to operate these 4 exceptions very carefully so as not to take away the essence, germ, whatever you call it, of 26(b). That is my submission. Please cut off 115. Now, one digression for 2 or 3 minutes to correct what I believe is an error by Justice Khare with greatest respect. Will come here. So, you know, it should be right here. After 115 will be para 84 at page 67. Lord should be right here after 115. Please read para 84 at page 67. Just a short digression. My Lord recollects I told Lordship not to read TMA Pi there. So now it comes here.
Which para?
84 at page 67. What happened here?
67.
Yeah. What happened in this 11th judge judgment was, that there is a passage, I won't take you there to save time, by Justice Khare. Kindly read 84 straight away. It was observed that the absence of the phrase other provisions of this part in the opening sentence of 26 would not mean that 26 is over and above any other right conferred by part 3. I hope I'm clear. It's a very, very, very important correction which I would request 9 judges to clarify. The lordships can do it notwithstanding 11 because it's obiter, completely obiter and doesn't exist. A, it is obiter, B, the para doesn't exist.
There's a purpose why other parts of part are not inserted there.
Now this, if I'm right here, the way I put it, summarized TMA Pi, it will have very far-reaching repercussions. So I am saying that TMA Pi suggests that it would not mean that 26 is over and above right conferred by part 3. That means the lordship is giving no effect to the omission. I hope I'm clear with this. Why did it happen? The court, Justice Khare went on to say, in Dargah committee, there is one case he cites, and Tilkayat is the second case he cites. It has been held that 26 is subject to 25, irrespective of the fact that the words subject to other provisions of this part occurring in 25 are absent in 26. It's a very, 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 very far-reaching proposition. It rewrites the constitution. Now, the simple answer is twofold. One, this did not arise in TMFI at all. It didn't arise. So it's in that sense, I mean, nothing can be obiter about 11 judges, Malas. Nothing is obiter about 11 judges, but in that sense, it's completely obiter. Second, see my A was A. We checked up, I hope I'm not wrong, we checked up very carefully. Astonishingly, the above conclusion by Justice Khare, while based supposedly on Dargah and Telkayat, is rendered per se inapplicable and indeed per incurium, for the simple reason that no such conclusion can be found in either of those two cited cases. These words are supposedly in the concurring judgment reflect an error patent. Secondly, Malas, the proposition is completely obiter, cannot be treated as a judgment of 11 judges for two simple reasons, namely, no issue of 25 and 26 arose in the case, it was 29 and 30.
Minority rights.
Yeah. So, of course, everything is related. I'm not saying 29 is divorced from 25, but your Lordship's basic approach was 29 and 30. And no other judge out of 11 judges, majority or concurring or dissenting, adopted this view. Namely, that 26 would be subject to, well, actually, you are rewriting it the opposite way. What just Dr. Ambedkar omitted, you are writing it into the Constitution. So it can't be, well, can't be. The proposition is also obiter because these observations were made as an analogous reference to support the conclusion arrived at by Justice Khare in the subsequent sentence, which was on the interpretation of 29, 2 and 30. So Justice Khare himself is dealing with 29, 30 in the next sentence. This 5 and 6 had no reason to find its place there. No reason at all. And then two more paras, next para, D, page 39, 80, 39. Yeah, 39. You don't keep it 69. 69. Keep it open on my para. 69. The use of articles 25 and 26 in analogy and the reference to Dargah and Tilkayat was in fact, Justice Qadri noticed this. He's a dissenter. So Justice Qadri notices and says that it is inappropriate and logically inapplicable. That's the dissent of Justice.
6A gives the right to maintain institutions for religious and charitable purposes. That was, there also it was concerning minority institutions.
Yeah.
And charitable institutions.
Yeah.
Where
Well,
there is no profit motive.
Well, it's the
etc.
main,
all that was considered.
the main issue was actually on educational rights.
Yes.
And 29 and 30 were the main focus in that entire case. There were, of course, references to others. Anyway, Wallace, my point gets support from Justice Qadri's dissent at page again.
There can be religious minority.
69, Justice Qadri's dissent, and that is footnoted with the exact page in footnote 78, where Wallace, at page 2310 and 2311, Justice Qadri points out that this is nowhere found in Tilkayat and the other one.
No, maybe in the context of a religious minority institutions.
Yes.
That stray reference must have come.
Yeah. This fellow need not trouble your lordship. Lordship must clarify this, otherwise it can have a very far-reaching effect. If this is read as it is, it can have, it can turn the whole article upside down. Not 85? No. Now, your lordship will go back
Page 84.
to page 84.
Page 84.
This was the diversion I took on Wallace. Your lordship now at page 84.
118, para 118.
Yeah. Page 84, para 118. That's where your lordship were.
Paragraph 118 or 9?
Page 84, para 118. It is further submitted, though no clue is available either in the debates or in the case law as to why 26 was not made subject. One reasonable explanation would be the fact that the right of collective groups and or denominations to establish and maintain religious institutions, and more particularly to manage their own affairs, would necessarily inevitably involve a certain degree of exclusion and or discrimination and classification. Then what is the rest is there. And your lordship will now come to issue 4. Where I strongly disagree with the frequent use of your lordship's constitutional morality. Now I'll skip half or more than half because those cases, but I'll point out some interesting things not pointed out. My submission in a nutshell is this, fellows. in a nutshell only, you can note it down because A, constitutional morality was used, this you may want to note down to make it shorter. This is a serious, I would say,
This is that page?
error or digression. I'm now on page 85. It's issue 4. We are coming to the end now shortly, hopefully. Issue 7 will not take time. So, this is on morality, constitutional morality, I'm sorry. My propositions are 1, constitutional morality is not used in the constitution anywhere. This is different from what is there. Different, note it down. 2, Dr. Ambedkar, whose passage is frequently quoted, used it to justify one allegation or question raised against him. Why are you providing such a detailed constitution, nitty-gritty? Why not a broad constitution? He said that in a nascent republic like India, where constitutional morality may be in a superficial topsoil, but not embedded in the subsoil, it is necessary to provide details of administration, which over time will inculcate and create that morality, which doesn't exist today. Totally different, quoting Grote, totally different context. Why you don't have nitty-gritty constitution? Why do you have nitty-gritty constitution? Why not have a general constitution? Third, constitutional morality was never dreamt of by anyone as an additional ground of derogation. Namely, I am a petitioner today, I challenge law X before your lordships, and I say, forget 19.2, 19.3, 19.4, forget some 25.1. In addition to all those derogations, decency, public order, morality, I challenge this law on the ground that it doesn't satisfy constitutional morality. That can't be a ground of invalidation of legislation. Cannot be. Unfortunately, it has been used in some judgments by simply following the previous judgment. I'll show that in a minute.
Legislation cannot be struck down on the ground of
On
constitutional.
a new head, I mean, you can say,
Part 3 or any other constitutional provision or legislative competence.
yes, that's it. That's it. Those are known to your lordship, 19.2, 19.3, competence. 25.1 has those words. There is no such thing as constitutional morality. Number 4, the framers consciously used morality. Why did they not use constitutional morality? Your lordship's fellows cannot rewrite that it's a term of art. By adding a word to a term of art, there is confusion created. There is already a term of art called morality.
19.2 it is there.
Yeah, it's
Decency
25.
and morality.
No, 25 also, everywhere. It
Yes.
Point is, your lordship never thought of using constitutional morality. If they were concerned about Dr. Ambedkar's one sentence in a different context, they would have put it there. As simple as that. Now, with that light, just see how the error occurred very, very quickly. Much of this has been read. I'll skip that verse. Much of this is covered in the. So, let's come to page 85, issue 4. This again, I think the Constitution 9 judges bench should clarify. And lordships can retain the phrase if it means general convention, general spirit. I have no problem. I mean, your lordship is not supposed to act without a convention, without a spirit.
Putting it.
Your lordship is not supposed to act without any idea of the legacy of the Constitution.
Right.
Your lordship is not supposed to act in a jungle that there is nothing before that. But your lordship is not to take it to this level. Now, what is the scope and extent of the word morality under 25 and 26? And whether it is meant to include, so this issue 4 is on morality, not on constitutional. It says, can you include morality under constitutional morality? Answer is no. That's the issue your lordship is framed. Now come to 122. These are all parts not read by my preceding learned counsel. Even at the time of drafting of part 3 of the subcommittee on fundamental rights, the apprehension was expressed by members of the subcommittee. Term morality was vague, incapable of precise definitions, susceptible to misuse. Mr. K.T. Shah, the evergreen Mr. K.T. Shah, he was always intervening. Article 9 should read like this. The last named is a very vague term. Its constitution changes substantially. Its connotation changes substantially. In a land of many religions with different conceptions of morality, different customs, uses, and ideas, it will be extremely difficult to get unanimity on what constitutes morality. If this is not to degenerate into a tyranny of the majority, necessary to define more clearly, etc., or to drop this altogether. Then Chief Justice Hidayatullah gives a useful formulation in para 124 in the famous Abbas case, the obscenity case. Whether we regard the state as the parent patriae or as guardian and promoter of general welfare, we have to concede that these restraints on liberty may be justified by their absolute necessity and clear purpose. The larger interests of the community require the formulation of policies and regulations to combat dishonesty, corruption, gambling, vice, and other things of immoral tendency and things which affect the security of the state and the preservation of public order and tranquility. So, these are the concepts of morality, that is decency, immoral tendency, etc. Then, in that film case, Rangarajan, 3 judges, third line, para 125, said, morality must be understood bearing in mind the cultural heritage of our country, the teachings of our great sages, and the concept of dharma. And again, there is a discussion of morality in 126 in the hotel and restaurant case by Justice Sikri. Just read this. This is very accurate. This is well put, I would say. Just read this 126. It needs to be borne in mind that there may be certain activities which the society perceives as immoral per se. Per se is important. It may include gambling, though not, it is becoming a debatable issue now, prostitution, etc. However, a practice which may not be immoral by societal standards cannot be thrust, there's an error there, upon the society as immoral by the state with its own notion of morality and thereby exercise social control. Furthermore, in any case, any legislation of this nature has to pass the muster of constitutional provisions as well. We've examined the issues raised. Here you are going much further. You are not only interpreting morality, you are adding one more phrase in the Constitution and constitutional morality. Now, 128, Keshwanand Bharati used it first. This doesn't at all bind you. It is used in a passing, completely passing, in by Chief Justice Ray. Lordship will just note my 128. This I'm not reading because Mr. Mehta has mentioned Keshwanand. Chief Justice Ray used it. Remember, he was technically on a minority on the basic structure. He used this phrase in the same words as Dr. Ambedkar. So what Dr. Ambedkar meant, Chief Justice Ray could not mean different, which was directly contrasting nitty-gritty constitution versus a general constitution. Then SP Gupta again done. So Keshwanand is 13 judges, SP Gupta is 7 judges. 129, I'm not reading, that's been read. Now 130 has not been read. That's how this became actually after Keshwanand, which is 50 years ago. And SP Gupta, which is 35, 40 years ago. Constitutional morality never acquired an importance in our jurisprudence. It was resurrected by a case not read to your lordships, Manoj Narula.
No, SP Gupta, probably it was correctly applied.
Yeah, but you're not a major doctrine.
It's not as to test any legislation.
Yes.
But the duties and responsibilities of constitutional authorities under the Constitution, it was rightly applied.
So, I've said.
The whole case dealt with that.
So, I've said, spirit of the Constitution.
Regard to the executive versus the judiciary.
Spirit.
Or the vice versa.
Conventions, legacy, your general spirit of the convention. That's all right, no problem. But now see how Narula deals with this. Manoj Narula.
We can't wholesale throw it away.
No. I am in fact asking for his retention, but a clarification that it is not a constitutional doctrine of nullification by itself. That's what it has been elevated to. It's been elevated to that.
See, it may be a very, very, what you say, indefinite or a very fluid test to apply to strike down legislation.
So
that is it should not be applied.
So two learned
strike down a legislation.
So that's what is happening here. 2 learned judges with Manoj Narula, they happen to be the same judges in subsequent judgments. Repeated Manoj Narula and elevated this doctrine. Chief Justice Deepak Mishra and was then Justice Chandrachud at that time, as he then was. So kindly read 130.
Dr. Singhvi, the idea of constitutional morality, when you apply to Article 2526,
yes,
is actually regulating non-state actors.
Yes.
Whether do we apply the test of constitutional morality when we examine the religious practices or religious affairs, management of religious affairs by non-state actors?
May I respond on this? I would say that the moment your lordship is entitled to look at religion and religious practices only in a subjective objective test, in the way I said in the morning, with a prism looking through the eyes of the adherent, any doctrine like constitutional morality brings in an external standard, whether by private or non-private actors,
No, that is.
and becomes very dangerous.
You're absolutely.
Very
right.
dangerous.
That is what we want, a more clearer
Yes, so I'm answering that.
submission on this.
Yes.
That whether, when you see Dr. Ambedkar's reference to constitutional morality.
Yes.
Constitutional morality being referred
Yeah.
in S.P. Gupta as conventions, practices of constitution or statutory or organs of governance.
Yes.
Will that same standard be applied when we apply morality as expressed in Article
With
26?
greatest respect.
When we are examining them against the backdrop of non-state.
So, well, it's-
That is to say,
My-
whether there will be a horizontal applicability.
so my respectful submission is an emphatic no.
That's-
Very clear no. Look at the kind of repercussions your lordship's query, Malus, if observed in the yes, would have. Just kindly consider. Your lordship has a derogation given in 25 of morality. Now please apply another standard called constitutional morality in 25(1). My lords has an exception of morality in 26. Please apply another one. Third, religious practices which all of us, well, not all of us, well, all of us on this side of the argument agree should be viewed through the prism of the adherent, which is largely a subjective view with some objective standard. That the
This issue
should be decided by constitutional morality now.
This issue was actually discussed in Kaushal Kishore in
Yes.
respect of 19(1)(a).
I think that's-
And the bench had made that distinction
Yeah.
between expressions by individuals holding public office and private individuals.
Well, I will,
Public office holders are put to a much higher, stricter test of adherence to constitutional
So, that's
conventions
my-
of decency and
well,
obligations.
I
which
don't-
May not apply to non-state
I
actors.
don't have caution in my submissions. I'll give a one-pager tomorrow, etc.
It was in the context of hate speech.
Yes,
Hate
but-
speech.
exactly, hate speech. But,
And you see Amish Devgan also,
yes, same.
because we are testing the same.
Correct, correct. Amish Devgan,
19(1)(a) against decency and
similar
morality,
issues. Similar.
vis-a-vis religious affairs against morality.
So having submitted to your lordships what constitutional morality is not, it is my duty to say to what extent what it is. It can be retained provided it is limited to a concept of convention, spirit, and acting in the interstices of the silences of the constitution.
Or a constitutional entity.
Yes, correct. But in the silences, the moment it comes into conflict with anything and your lordship starts elevating it as an overriding consideration, then well, it is contrary to the constitutional ethos. That's the law. I was going to come to that conclusion. I'm just giving your lordship the direct conclusion now.
So in other words, sorry,
If we see constitutional ideals
Yes.
as encapsulate or as a charter of constitutional morality, then all excise provisions
Yes.
regulating and permitting you sale of liquor
Yes.
should be held to the qualitative of constitutional.
Yes. Yes. Absolutely. And whose constitutional morality? Malas? Constitutional morality will also differ whether you're sitting that side or this side or this side. It can all differ, Malas. It is a new standard. Now, your lordship has trodden the path of morality and health in the cases. Even our words of the constitution were vague words in 1950 when the constitution came. But your lordship has created a jurisprudence over 70 years, 80 years, which has given flesh and blood. So we follow that. Now, today, we have a new word which does not have a legacy of jurisprudence. And your lordship must start again, was following a generally vague term. So at the highest, if your lordship were to preserve it, your lordship should use that famous phrase of Michael Foley, that lovely book, Wallace, constitutional silences,
in other words,
constitutional pauses.
you're saying on the touchstone of constitutional morality,
Yes.
you cannot say a religious practice is bad.
Last and least of all religious practice. Well, it's the worst scenario, worst use of constitutional morality. According to me, it's bad everywhere.
Cannot be a subject matter of
In the,
debate in a
in
court.
the area of 25, 26, it can have disastrous effects. Let me be as frank as possible. If you bring in, it will be, if I may use in a lighter way, it will be a bull in a china shop. The China shop being 25 and 26. And the bull being constitutional morality. It will just not fit in, and it should not be allowed to enter. Now let's kindly come to 130. Page 88. The term constitutional morality is still 4 o'clock. Appears to have been recently brought into focus and applied in detail in Manoj Narula, which I footnoted at footnote 123 with all the at pages given. It's a detailed discussion, Manoj, in footnote 23 at pages 1375 to 1383. 8 pages. Along with the use of good governance and constitutional trust. Constitutional trust is also a very good word, Manoj.
In this part, we have also understood.
I'm leaving it, Manoj. I'm leaving it. Now here, Manoj, Chief Justice
Plus
Deepak.
term, probably,
Yeah.
you are only, the explanatory note says, as we used to call it a constitutional dharma or a constitutional code of conduct,
Yes.
which the constitutional functionaries are expected to observe
Yes.
in their functioning,
Yes.
is what can be termed as constitutional morality, that you will follow those principles
Yes.
that the constitution expect you to follow.
Spirit, convention, legacy.
And therefore,
Basic.
this morality, constitutional morality is a different notion as compared to the word morality in 25
Eight.
and 26.
And it does not mean the same. And no, one more thing. And you must apply it extremely cautiously and sparingly across all constitutional provisions, but the most across 25 and 26.
Understood.
That is very important. It is genuinely likely to cause havoc if you apply it loosely, because in religion, constitutional morality will have real consequences, very serious. Now, the next major expansion of this is 132, the NCT case constitution bench, where Justice Chandrachud took it further. This is para 132. Manoj Narula then very heavily expanded in NCT. This is NCT 1. I had occasion to appear in both NCT 1 and NCT 2. So it went. Then your lordship has all those judgments I have given in 133, 134.
Now this.
In 135 is Navtej Sarna, where it is given great primacy, but again by the same 2 learned judges. Chief Justice.
The danger of constitutional morality in this context will be the unmanageable standards of
It's not an unruly horse, it's a dinosaur, your lordship can't ride.
Introduce complete subjectivity and individual opinions.
It's not an unruly horse, it's an unrideable animal. You can't manage it. Then, in 136, your lordship notices Melis, what is happening? Sorry. Is that the same paragraphs are repeated in all these cases again and again. So they become embedded in your jurisprudence. If your lordship, I don't have time now. If your lordship will check these paras, it's the same para of the previous case which finds the next case. And Malus, in most of these cases, the same 2 learned judges. Now it's very interesting. It's very interesting. In 139, I'm sorry, before that, in 137, Justice Nariman in Navtej, Navtej Sarna applied a small corrective. He said, I don't accept any of this constitutional morality. It is only a phrase in contradiction of Victorian morality. So he puts a word of caution. He makes it clear in Sabarimala also later on. I'll show that. So your lordship sees the end of 137. Then in Shaira, it is very interesting that Chief Justice Kehar directly opposes constitutional morality. Now, Chief Justice Kehar, in the result, is seen as a dissent. But on this point, 3 learned judges agreed with him, and I've just given, let me go out of sequence. Go to para B at the bottom of 91. So he was a dissent on the result. This is the triple talaq, it's a triple talaq case. But in this reasoning, he was joined by Justice Nazir. Now come to his reasoning at para 139. It is not possible to adopt concepts emerging from the American Constitution over the provisions of the Indian Constitution. Therefore, not possible to refer to substantive due process as the basis for the decision of present controversy when there are express provisions provided. It is also not possible to read into the Constitution what the Constitutional Assembly consciously and thoughtfully excluded. The prayer made to the court by those representing the petitioner's cause on the ground that the practice of talaq-e-biddat is violative of constitutional morality. That was the argument. Here you also see the level to which you've taken it with us. There were other grounds you could deal with. You could have done it this way or that way on other grounds. But one of the grounds in the majority is on this verse, constitutional morality. So he says cannot be acceded to and is accordingly declined. Then the practice of talaq-e-biddat being a constituent of personal law has a stature equal to other fundamental rights. The practice cannot therefore be set aside on the ground of being violative of the concept of constitutional morality. I'm only concerned with that. Other thing what you did is different matter, whether public order, health, etc. Chief Justice Kehar's opinion is commonly construed as a dissenting opinion, page 91, as he was a minority in terms of final outcome. However, it is highly arguable that Chief Justice Kehar in fact constitutes part of the majority on the issue that no other derogation from 25 and 26 is permissible. Because he is joined by Justice Kurian in A and bottom joined by Justice Nazir. I'm not reading the court, but Justice Kurian agrees on this part.
Justice Korean view you have reproduced, that appears to be the correct statement of law.
Yes, yes.
140 subpara A.
I'm grateful. I'm very
Lordship has correctly.
That's it. That's it. Except last para, just above B.
I think
Except,
143, where you have highlighted those para, maybe Dr.
Yes.
Ambedkar's
yes,
statement, I think that
absolutely.
will enlighten everyone.
Then, the summary is at 142. 144. No, sorry, before that, 142, just for a minute, 142.
Yes.
There comes Joseph Shine's judgment. So we travel through 5 judgments. Manoj Narula, NCT 1, NCT 2, Chaira Bano, and now Joseph Shine. This is the adultery case, so-called. Pertinent to mention that Supreme Court has considered the concept of constitutional morality in a constitutional manner. The main judgment of 2 honorable judges, again delivered by Chief Justice Mishra, 3 separate concurring judgments. Now, no judgment except Justice Chandrachud repeats this. Chief Justice Mishra and Justice Chandrachud. So it's a succession. That's what it is noteworthy that none of the judgments deal with constitutional morality except that. And there is a 1 para reference to the same by Justice Nariman. Now, just bear with me. I will not read it, but just see 93 is the actual quote of Dr. Ambedkar. It is crystal clear beyond doubt that he's talking of nitty-gritty constitution versus a general constitution. I don't have time to read it. Please take my word for it. It is quoted in full in 92 to 93. It is read earlier. I am not reading it for that reason. I'm not reading anything read earlier. But it has to be borne in mind. He is only contrasting it to say that the topsoil may be some, but we have to create a subsoil. And for that, I have to give nitty-gritty provisions. And that is how I will create constitutional morality in the long run. And he quotes Grote. That's all. Now, page 94. Para 144 is a useful summary. A bare reading would show that Dr. Ambedkar was in fact accepting that a large number of details, nitty-gritty issues of administration as found in a governing British statute, that is GOI Act 35, were being borrowed and incorporated in the new draft constitution. Dr. Ambedkar was regretful of the fact that an apex and hierarchically superior document like Constitution of India should incorporate details and nitty-gritty issues, which more correctly ought to be left out to a hierarchically lower statute. He, however, expresses helplessness to the fact that the absence of constitutional morality, not to be readily assumed to exist in a nascent constitutional republic like India, did not enable or allow him to leave such details to be worked out by a future Indian legislature. This is the heart of the reason which he gave us. The absence of such CM in a future legislature, according to Dr. Ambedkar, compelled him to put such a high degree of detail of administration. So he said a legislature may not give these details and will not be able to create that. It was in this context the meaning and scope of CM, constitutional morality, by reference to Grote was discussed. And then was F. Noteworthy, the aforesaid remarks were restricted to the legislature. That's another point, restricted to the legislative organ and had no reference to judicial organ. Dr. Ambedkar never dreamt of it as a ground for a lordship judiciary. He was talking about legislative organ only. It is therefore clear that Dr. Ambedkar preferred the specificity of constitutional text to obviate and preclude reliance, etc. Then, Malads, I will come to 147, the Lordship's query that answered clearly by they consciously omitted to use constitutional morality. Word uses morality. So please don't conflate the two. That's 147.
148.
148, Malads, is just a nice quotation. I left it to your Lordships to consider. John Selden is a little known man, Malads, who was a conveyancer. He never appeared in court, Malads, but he was a antiquarian who collected conveyance documents in the 16th century, Malads. The Chancellor's foot is ascribed to him, Malads. Equity is so this was constitutional morality, apart from being a bull in a china shop, would be a Chancellor's foot in 25-26. Who the Chancellor will be, whose foot it will be, I don't know, Malads, but certainly this would, equity is a roguish thing, a roughish thing. For law, we have a measure, know what to trust to. Equity is according to the conscience of him that is the Chancellor. And as that is larger or narrower, so is equity. T is all one, as if they should make the standard for a measure we call a foot, a Chancellor's foot. What an uncertain measure would this be? One Chancellor has a long foot, another has a short foot, a third an indifferent foot. T is the same thing in the Chancellor's conscience. John Selden with us. 149, and this is clearly what in 25-26 in particular in 25-26. Then Wallace objectives resolution is where Wallace part 3 started before the Constituent Draft Assembly. Nehru's objective is a very short Wallace half-page objective resolution. There, public morality was used. No constitutional morality. This is the precursor, if I may say so, of part 3. The immediate precursor of part 3. And Dr. Ambedkar at that time was using only morality, not even public morality. I've quoted it. He was using morality, not even public morality. That's para 149. This is a discussion 4 days after the objective resolution. Objective resolution by Nehru is December 13, 1946. The discussion is on 17th December, 4 days later. On 18th December, in para 150, again brought to in the phrase public morality, but ultimately on 1 May 97, Sardar Patel, while moving for adoption of clause 13, which now has become 25, used the word morality instead of even public morality. That's how it settled down. Public morality, then ultimately came morality, finally.
But in one of the judgments,
notes this. My lord is right. It notes this. And whereas para 151, in particular, the dangers of departing from fidelity to the constitutional text and adopting phrases clearly not adopted can have serious and hazardous consequences. Well, it's Supriyo.
Come like Chancellor's foot.
That's why I quoted it. Well, it's 154. Your Lordship may have to overrule this formulation. Page 97. As for morality, it is settled the law that 25 speaks of constitutional morality and not societal morality. If your Lordship lets it be as it is, it's a very major. It's like the Justice Khare doctrine was. I hope my Lordship has got that. This is completely wrong. Completely wrong. Now, this, of course, is possibly a dissenting judgment. I mean, there are some parts he's with Justice Kaul in the majority, some parts he's not. But this should be well as clarified and eliminated. Justice Nariman got it right in 155. Kindly see that. In 155. In this very case, Sabarimala, where Wallace, I had the privilege of opening the case and we lost 3-2 in the original judgment. So Justice Nariman is part of the majority, which is now under review. Just see the footnote at page 98. The last footnote.
we are invited.
Yes, we were invited by the learned amicus, Sri Raju Ramchandran, to read the word morality as being constitutional morality, as has been explained in some of our recent judgments. So already you had Manoj Narula, NCT, everything you had. If so read, it cannot be forgotten that this would bring in through the back door the other provisions of part 3, which 26 is not subject to, in contrast with 25(1). In any case, the fundamental right under 26 will have to be balanced with the rights of others contained in part 3 as a matter of harmonious construction, as was held in Devaru. But this would only be on a case-by-case basis without necessarily subjecting fundamental rights under 26 to other fundamental rights contained in part 3. He was not dealing fully with it, but this, he doesn't like the word CM to be getting it from the back door. That's it. Now, whereas 156, etc. end. Now, issue 5. Your question is, what is the scope and extent of judicial review with regard to religious practice, as in 25? Now, 162, morality is done with. We've dealt with it fully. Public order is well established, and I, with respect, submit that a 9 judge needs no need to interfere. According to me, the best description remains Ram Manohar Lohiya's 3 circles. The Lordship knows 3 circles. Smallest is security of state, middle is public order, and largest is law and order. 3 concentric circles I have quoted at page 100. We are now discussing judicial review of public order. This is what has stood the test of time. Unless your Lordship feels that something needs clarification, this is a good conceptual description. Now, 101. This is on public order, 100. Page 100 was on public order, which is the exception which your Lordship reviews. 101, third line. Judicial review, therefore, must be exercised with caution and restraint so as to ensure that interference with religious practices occurs only once such practices demonstrably affect the community at large or threaten public order, rather than merely constituting a matter of internal religious observance. It has been held by this court in a number of cases, I'm reading 165 para number, that public order is different from law and order. Every act that constitutes a threat to law would not be subject. Then Ashok Kumar is cited. Then Ghulam Abbas is cited. Well, Ghulam Abbas has one para that in public order, peace and tranquility is important, but please guard that I cannot create a public disorder situation and then claim that his right must be curtailed. So, this man is practicing his religion. I create a public disorder and then I say, please curtail his right on the ground of public disorder. I hope I'm clear. That is what Abbas is making clear, rightly so. Because obviously public order is an exception to the religious right, but it has to come not from the complainant who has created a situation, taking advantage of his own wrong. Then 102 puts it well, page 102. In other words, the magistrate's action should be directed against the wrongdoer rather than the wronged. Further, it not be a proper exercise of discretion, part of the magistrate to interfere with the lawful exercise of the right of a party on a considering those who threaten or interfere constitute a large majority. And it would be more convenient for the administration to impose restrictions affect only a minor section. The third head on judicial review is health. Whereas the first point in health in para 167 is that health has to be, a threat to health has to be ultimately a matter of legislative policy. It's mainly a matter of legislative policy. The court neither has the power under our constitutional scheme, I'm reading 167, nor with the greatest respect, the expertise to formulate policy in this regard and lay down what is good for health in the public at large. The Supreme Court put it well in Vincent Wallace in 1987. The underlined portion. Similarly, the question of policy which is involved in the matter is also one for the union government, keeping the best interest of citizens in a view to decide. No final say in regard to such aspects come under the purview of the court. Next para, the branch with which we are now dealing, namely health care of citizens, is a problem with various facets. It involves an ever-changing challenge. Godawat, the Pan Masala case, they say at page 103, we are unable to accept that words in the interest of public health used in section 7 can operate as an incantation or a mantra to get over all the constitutional difficulties posited.
I think paragraph 170 onwards.
Yes. Now, this is dealt with fully, Malas. This is dealt with earlier fully. Other provision of this part, I'm skipping, Malas. I'm skipping. Now, Malas, 104 page number. Your Lordship will come to the last para, Bijo Emmanuel. That's a nice Malas principle. We do endorse the view suggested by Justice Davar's observation that the question is not whether a particular religious belief or practice appeals to our reason or sentiment, but whether this is part of judicial review. The Lordship is now in judicial review, this section. So how do you do judicial review? Do it like this. But whether the belief is genuinely and conscientiously held as part of the profession or practice of religion. Our personal views and reactions are irrelevant. If the belief is genuinely and conscientiously held, it attracts the protection of 25, but subject, of course, to the inhibitions contained there. I've divided it in para 176. I've broken it up. Now, this part of 25(2)(b) has been fully covered. The heading, next heading. Your Lordships can, Maras, come to para 180 at page 106. When evaluating legislation providing for social welfare and reform, the court must bear in mind, as Justice Iyengar said, one, Malas, limited inquiry, that I have quoted again, reform a religion out of existence or identity. So one is limited inquiry. The court's role is to determine whether, well, I'm putting my caveat on essential, but that's the word of the court. Don't think I'm advocating essential, just quoting it, just the error is there. It's subject to my essential caveat. This inquiry must be based on the tenets and doctrine of religion itself, not on the court's notion of what is logical or rational. The question is not whether practice is essential to Hinduism, but whether it is essential to the worship at this specific denominational temple. They do use the word essential. I made my point clear. Deference to ecclesiastical authority. What constitutes an essential part of a religion is primarily to be ascertained with reference to the doctrines of that religion. For the Sabarimala temple, the foreign authority is etc. etc. I've given that. And then evidentiary basis, mixed questions of law and fact. I'll be ending on a very important issue 7 chart I'll be giving your Lordships. What we are having today, whether your Lordship allows it in this case or not, is a complete inversion of the discipline of law. I'll end on issue 7, leave it now, don't go into now. Now come to issue 6 at page 107. What is the meaning of the expression section of Hindus in 25(2)(b)? Now, I have already done the corrigendum addendum B on 25(2)(b). That's my main submission, the first words and the second words.
You-
Access and
Yes,
social...
Singhvi, you finished with constitutional morality.
Oh, yes.
No, that was, now we are moving on to another.
Yes.
So why can't constitutional morality be interpreted to mean differently and to be interpreted in different ways in different scenarios? Why is the blanket constitutional morality should be not read at all into? We could define that there may be parameters and different type of reading what actually constitutional morality would mean. But why straight away that no, this will not apply?
I've said repeatedly, I appreciate, I'm buying down. I've said repeatedly, to the extent that in the interstices of constitutional silence, with no competing law or directly occupying legislation or delegated legislation, where your Lordship finds that your Lordship can rely on conventions, on spirit, on legacy, your Lordships can and should use. Very clear answer I'm giving. But where?
No, but the definition itself should not be a straitjacket. It is a fluid concept.
Of course it is. All morality is
Itself is,
absolutely.
and the emphasis is more on what happened 70, 75 years ago in debate. Can't that be now?
No, therefore, Malas, it would be contextual to the case.
The debate was that somebody did not want to introduce, somebody did want to introduce. With reference to the context, why can't constitutional morality be read?
Let me. If your Lordship were to elevate and use constitutional morality as has been used in 4 cases, I'll give you a very clear answer to my Lord. That is Manoj Narula, NCT 1, NCT 2, and Malas, this Navtej. Where it has been used as a major ground to invalidate or dilute legislation, then Malas, I would say it's wrong. 1. 2. Why it is wrong? Your Lordship will use the origin of Dr. Ambedkar. Your Lordship is not, I'm not saying that your Lordships can't evolve that doctrine. But why this use is a misuse is because it has no connection with the concept of Dr. Ambedkar. That's why Lordship is seeing Dr. Ambedkar. All these judgments are quoting Dr. Ambedkar. They are quoting Grote. So it is important to note that it has nothing to do with this issue. Third, if your Lordship is not dealing with a legislation or invalidation or dilution, etc., and in particular, one is 25-26, and your Lordship finds that the interstices can be filled up with some convention, some legacy, and this will depend from case to case. It cannot be answered generally. Your Lordships may have recourse that, look, constitutional morality for me in this case means that the convention has always been that the governor will give an address in the beginning, and the governor is bound by giving an address to read whatever is given to him. I'm giving only an example, but only give an example. It may be a self-serving example, but it's an example only. So, that provided your Lordship is not validating or invalidating or otherwise testing the touchstone of anything which is occupying. Otherwise, your Lordship would be giving, then your Lordship will see in 25-26, can your Lordship elevate it to a 6th or a 7th derogable standard?
No, not for a minute I'm suggesting that. What the query of the court is probably, I'll just rephrase that.
You can evolve it.
No. Dr. Ambedkar also said the relevant point that let the nation develop. Constitutional morality as a word should not be there. But after 75 years of independence, if the experience is that it has not developed the way it should have developed, can't there be an interpretation of a concept of constitutional morality in reference to the context, not as a blanket jacket formula?
So I will say, I don't like absolutism. I would concede. But it's a very careful, cautious, incremental move your Lordship will have to make. A, contextual. B, there is no competing occupied field. There is some constitutional pause and constitutional silence. And then your Lordship will say that, look, today's current constitutional morality requires this to be, it's another form of purposive or teleological interpretation also. Your Lordship could have a purposive teleological, your Lordship can advance the ethos.
You may have a point that the way it has been described
but this
by
is
the
used totally differently.
may need to be relooked.
It has to be very incremental and cautious. Well, it's been used as a very wide battering ram for many situations. That can't be.
See, a duty to be performed under the constitutional provisions, if not performed, it can be said that there is, breach of constitutional morality.
Contextually, if your Lordship controls it, I have no problem with it.
Not as a touchstone.
And I'm not asking for its excision.
Legislation.
I'm not asking for its excision. But it has to be clarified and controlled, which it is not. And only 9 judges can do it because all these are constitutional benches, 5 judges.
We have understood your contention, Dr.
Now,
come on issue number 6 now.
6. Now, this is on this access.
Sections of Hindus probably. Do you want to?
It's done. It's done. It's done on 25-2B. It's done. No, just one thing. I have not cited Khandekar, who said in the last but one line, private temple. The point I've already covered. He made that point. He said it can't apply to private temples. Then, 184 is tracing, 183 is tracing the evolution of how section came. Original was, not the word section. Where is that original? Original is where? Just see 181. The original was any class or section of Hindus. And your Lordship comes to para 184. Dr. Munshi introduced by an amendment or a section thereof. And then, in 185, every religious denomination or a section thereof shall have the right. And then, Durgabai Deshmukh, any class or section, all classes and sections be substituted. That's what she got in Any class became all classes. Now she explains it in 187. The founder of India International Center was her husband. She has a very strong lineage independent of C.D. Deshmukh was
C.D. Deshmukh.
he was a zoologist who planted all the trees and the plants in IIC himself. Sir, in my view, the clause as it stands is restricted in its scope, and the object of amendment is to secure the benefit in a wider way and to make it applicable to all classes. She is now canvassing for all classes and sections. Though we are not able to make a sweeping reform, I feel no distinction of any kind should be made between one class of Hindus and another. But I am equally sure that some distinction does still exist in regard to the other forms of religious institutions, such as pathshalas, educational institutions, and others managed or conducted by these religious institutions. As I have already explained, my object is to enlarge the scope of this clause and to include within it all classes and sections of Hindu. The said amendment moved by Srimati Durgabai was accepted. This is why all sections came in, all classes. Then Mr. Pillai in 190 supports the motion, all classes, and he talks about discrimination. Though it was the first part was reform and social welfare, most of the debate's focus was on exclusion of entry and access. So the real focus is entry and access, though we have two parts to it, no doubt. Right. Then 191 is the definition of backward class and section of Hindus. And Mr. Chandrika Ram and also to some extent Mr. Dharam Prakash brings in scheduled caste and backward caste as specific references. Para 194, Dr. Sitaramaiah talks of the untouchability. Most of the focus was on access and exclusion of entry. Your Worship notes 195 that its words include all community and it is not gender specific or gender based. All. 199 is a judgment only to note the expansion of Hindus, which the word sections covers. Because by then they said you must include Jains and Sikhs. So that is para 199. Hindus is deemed to include by deeming fiction, not otherwise. Then I will skip 200 and Nagraj.
7 you can.
Yes.
So.
And now conclusion is given in 114. Now 7 is important and interesting. I'll be very brief, but it's important. There are two issues in 7 whether a person not belonging to, whether a person not belonging to a religious denomination or religious group can question a practice of their religious denomination or religious group by filing a PIL. The issue subsumes two different issues. Whether a person not belonging to a religious denomination or religious group can question a practice. This is one issue. A separate, more important issue is the frame of the proceeding. I'll address B first. Well, I have put 23 judgments in a chart. All of them reaching the Supreme Court in 25-26 have come up through a ladder. And all of them have come by being initiated by an adherent of the religion who challenges the inroad into his 25-26. So I'm an individual or she's a denomination. You have inroded or intruded by legislation or by some form of legislation. I am the challenger. Your Lordship actually has to comment. Your Lordship allow it in this case. I understand it's 10 years old and all that. This must be clarified in this judgment, 9 judges. The entire frame of the proceedings is inverted and put upside down.
This is what my sister has said.
Justice Nagarata said so. I was there the first day.
Yes.
No, but it's much. Give me a few minutes. It's important. Your Lordship may have to just sit a few minutes beyond time. I'll finish. Just a few minutes if possible. The frame of the proceedings must be, I have a right as an individual 25-26.
We will sit 10, 15 minutes
I'm
beyond
grateful.
4.
I'm very grateful. I'll finish then. I'll finish. I am an individual who has 25-26, 25 rights. She is a denomination who has 26 rights. When either of our two rights respectively is intruded upon by my learned friend's clients, by legislation, delegated legislation, whatever, which I think is diluting my right, I go in a writ, I go in a suit, I go in something. I'm the challenger asserting my right. And he is the defender showing I have rightly violated Mr. Singhvi's right because I come under public order, health, morality, or some other part of the constitution. Your Lordship decides it. 23 cases in my chart till 2025 December. Not one case of this kind. Now what happens when you turn that upside down? You don't have a challenger whose 25-26 right is affected. You don't have a legislation. Most important, legislation includes delegated legislation. You don't have a legislation. You have a supposed PIL petitioner coming and saying, look, I believe that this religious practice is not a good practice. And they may be right or wrong, is not the point. Now that chap who has a right under 25(6) is not the challenger. The government who can intrude and limit the right by public order, health or whatever Lordship calls it, is not the respondent. Both of us, me and the government, are respondents to the PIL's claim that according to an objective PIL collective consciousness standard, this religious practice is bad. That completely destroys the very concept, and that should not be allowed.
A believer will never question it.
No, that's the first part. No, but I'm going further. My Lord Justice Agarwal is right. Yeah.
Who is this?
Yeah.
Who is the petitioner?
So well, that's the first, that's A. I'm at the moment on B. Lordship comes to 115, I'm on B. My Lord Justice Nagarata is absolutely right. That is issue A. I am regarding B first. I am on the frame of the proceeding which your Lordship should never allow because it distorts the adjudicatory matrix for 25 and 26 completely.
Dr. Singhvi,
Yes.
if again
Yes.
a newfangled religious leader
Yes.
forms a denomination
Yes.
and says that a mass suicide by my believers will attain salvation if they do it on a particular day, then will not any individual be entitled to invoke public health and morality as a ground to strike down?
Let me answer. Let me answer. Allow me to answer. Your Lordship has traveled many, many millions of miles on PIL since it was invented in the 70s and 80s. So it's too far gone to say PILs are per se not maintainable. Nobody is saying
That is,
But your Lordship has to be very careful, which you are generally.
again, so the paradigm is on a case-to-case basis.
It may be more than that. I want to say it's more than that. Case to case, your Lordship anyway manages PILs as an unruly horse, and your Lordship finds it every day, you say dismissed or allowed, etc. In matter of religion, the normal, predominant and overwhelming role should be to prevent and discourage PILs. I'm going beyond the PIL jurisprudence. Your Lordship in an individual case says, I'm a motivated public, not a private interest litigant, a political interest litigant, a personal interest litigant, and you dismiss it. Your Lordship says, I've not given a correct affidavit. I've done 5 cases against this man, I'm malaffidavit. That's a different test. I'm now giving your Lordship a higher test in 25 and 26 in particular. Well, 25 and 26 is calibrated on faith, on belief. When your Lordship's judicial review is so careful about the collective belief, so everybody on this side, this collectivity has a belief. My Lord's test judicial review by going first through that subjective belief and then applying a slight objective test through that prism. Malas, how is it possible? Now, if a person says, my religion allows me to kill people or do something, then the state will come up with something. Or if some law and order is there immediately, your Lordship will have those extreme cases, PIL can come. Very well, let me say PIL can come, and that's an extreme example. But these are not those cases. What is the case here is that a practice established, well, I don't know how old Sabarimala is.
We are not discussing.
1,000 years old.
Huh?
How many years? Sabarimala?
It is from
It is,
1950.
your Lordship will take this case.
We are discussing
Sabarimala, 200 years old.
issues.
Guru Ayur, so many years old. Somebody comes and files a PIL saying this practice is bad.
Dr. Singhvi, the question, issue 7 is
Yes.
whether a person in exercise of PIL rules
Yes.
can approach the court with regard to a particular religious
So I'll not give a person.
communications, management of religious
I-
affairs.
I-
And my question to you is, if exercise or otherwise, the religious practice or affairs of management,
Yes.
the transgress the Lakshman Rekha of public order,
Correct.
or health or morality? How will the courts
So, Manas, my first answer is I will not go to
refrain
a
themselves from
very important.
entertaining such?
I will not give a per se answer. I will concede that I cannot argue that per se never ever will a PI lie. That's point number one. In the example which Justice Bagchi gave, possibly it may lie. I mean, a man egregiously giving some proclamation about
Today you are
Now-
suppressing our religion.
These are all extreme and exceptional.
extreme. No, therefore, let me give you flesh and blood to what I'm saying.
Why the court should even wait for a PIL? Why can't the court take suo motu action?
Now, you can take so exactly. Now, Manas,
The first constitutional drama of a constitutional court is that if this thing happens, why you wait for a PIL?
correct.
Why can't you take suo motu action?
Fully. That, however, does not mean that PIL becomes a vehicle for interpreting either a religious practice or its violation by public order. That cannot. So, Manas, your lordship's threshold for entertaining that kind of PIL will be 10 times higher than a normal PIL. Now, just Manas, your lordship will give me 10 minutes extra, lordship said.
No.
Yes. No, Manas, your lordship has your people there.
What?
I am already intimidated by 9-judge bench, Manas. I am now intimidated by 9 more, Manas. 9 more. And now let's 115. 115. This is very short, Manas, just 115. Manas, I have said the first para of 115 is a chart. Now this chart is at appendix 2 in my para 204A. This is very interesting. Manas. After all, for 75, 80 years, we've had these articles, we've had the litigation. Why did nobody try this? Your lordship can even allow it. I'm not saying this PIL be dismissed. But your lordship, law should be clear. Your lordships can allow this PIL to be maintained subject to your lordship discretion. It's too late in the day, perhaps, to say that the PIL, now you go back and start all over again. But your lordship should be able to lay down this law for 25, 26.
But regarding maintainability or entertainment of PIL,
Yes.
broadly, I think principles are well laid down.
Well, in 25, 26, it's a much more higher threshold is what I'm trying to emphasize. Now come to 132.
Maybe that your argument is that while entertaining a PIL,
Yes.
it is likely to have an impact on the rights of those who are not before us,
Yes.
under 25, 26,
Not that.
or maybe any other
This
constitutional right.
PIL's direct prayer is, the direct prayer of all such PILs is to change the practices. Manas, what is this PIL? This is not a PIL. Declare that these practices are unconstitutional or eliminate them. Let's forget Sabarimala, Manas, any other case. Now you are, Manas, religion is collectivity of millions, faith of millions. A third party is enabled by direct access to Article 32 to change it, and we are at the most defending. We are not able to show the contours of public order. So I say, look, what is wrong in this? There is no state respondent. I am a respondent. I should be a petitioner.
Can the court decide it without hearing the representatives of the millions? Now, as you were saying,
Yeah.
millions have faith.
Yeah.
Can the court decide the issue, well, over which the millions still believe in it, without even hearing them? And there is a
Absolutely not.
mechanism to hear them.
So, absolutely not. But that is only natural justice.
I think.
I'm going further. Your lordship are here.
Then,
Prior
court
to
decision
that, it
cannot be made binding on them.
It should not be entertained for the simple reason
Yes.
that such a person who files the PIL, who is not a believer, is not an aggrieved party,
That's
is
the-
not a stranger, is an interloper.
That's my part A. I'm coming to that, but just see this chart first, 132. Please ask the question, why in 80 years or 78 years of our republic, why this never happened? Your lordship, and 4 of these are suits with evidence. Just turn to 32. 132, sorry, 132. Kindly just
I
turn.
think beside the issue which my brother and my sister pointed out,
Yes. Note down.
the most difficult task for a court
Yes.
might be how to give a declaration that the belief of millions of people is wrong or erroneous. Or
That's what happens in a PIL. Unlike your lordships in a PIL that please demolish this illegal colony. Your lordship here, some association, your lordship is not deciding a corpus of a religion, which may be 1,000 years old, maybe 500 years old, maybe 200 years old. Your lordship is deciding a mega issue way beyond the meganess of a PIL.
So it is outside the scope of a debate
Yes.
under the constitution in a PIL. Such a question is beyond the scope of debate in a court of law.
On twin grounds, that PIL on 25 and on the ground that is by non-adherence to religion, both grounds. Now let's come to 132.
In fact, such a person will not be entitled even to maintain a suit under Order 1 Rule 8.
That's the next point. Well, it's coming in issue. Absolutely right, because it's coming in issue A. Your lordship will not entertain in a suit, but in a direct 32, you will entertain and change. But suppose this PIL succeeds, your Sabarimala practices will end.
In a civil suit, the court is very well within its jurisdiction to hold that a particular kind of ritual
locus.
is not that may not fall be among the religious practices. The court can hold on the basis of evidence.
May I ask, how are you aggrieved?
In a
What is
civil
the cause of action?
In a civil suit based upon evidence,
Yes.
the court might,
General principle.
May do that. May do. No. So therefore, just see 132 now. Let me show 132 once. We have had 80 years of our republic and many issues have arisen. I'll not take more than 2 minutes on this chart. A very instructive chart. First is Shirur Math, 54, writ petition. Always by the claimer of 25(1) or 26. Always. Ratilal, then Devaru. I've given all the details on which act, which section, what the issues. I don't have time to read it. All are given. Now the 4 of these are suits. 4 of these 23 are suits. Number 4 is Moti Mahendas SP Sai is a suit in Patna. And they had full trial, full evidence, full decrees. Then was 5, Dargah Committee, writ. Sardar Sayedna, Tilka, not a single collective, not even order 1 rule, 10 kind of collectivity with that representative notice in the newspapers and all, nothing.
Representative.
Yes, not even that. Then 8, 8 is a suit, is a second suit. Then Seshamal. So all these 4 of these are suits. At page 142, I've given the 4 suits out of this list. 142, 23 cases, none of them in a PIL format of this kind, none of them in a collective format, and 4 of them suits. And let me concede that PIL per se is maintainable. If you talk absolute per se, I'm not saying that. In a rare case. But please be extremely cautious. We'll come back now to page 115. Para 206. 115-206. Therefore, no judgment of the Honorable Supreme Court on 25-26 has arisen in the matrix and frame of a PIL. The only exception is Guru Vayur. There were some. I'll deal with that in a minute. Guru Vayur was filed before the Honorable High Court and the SLP was filed challenging the interim order passed by the High Court. Supreme Court in this matter actually raised the issue of maintainability. The point I'm arguing now, the solo case, but said we did not decide it because it has become academic since the High Court has adjudicated. Indeed, out of the larger list in Appendix 2, 4 involve civil suits. There should be 4. The number is 4. Your Lordship doesn't have number 4 can be written against 207. 4 out of these 23. The consequence, para 208. The consequence of a proceeding initiated, take out that one page on Sabarimala facts. Through a petitioner, give me a hard set. Petitioner is the religious denomination or group which would otherwise approach the court as a petitioner, challenging legislation, delegate legislation or state action as an intrusion is instead placed in the position of a respondent. In that position, rather than asserting my constitutional rights and challenging impugn action, it is compelled to defend its religious and denominational practices. It is unprecedented the present batch of cases effectively parachuted directly into this court through the impermissible framing of a PIL. In contrast, the overwhelming number of precedents referred to above have reached this court only after traversing the structured judicial hierarchy. And then it brings in mixed question of fact and law in 210. 210, mixed question of fact and law, Mahindran. Mixed question of fact and law is 210, Mahindran. I'll finish in 5 minutes, 5 minutes more. Mahindran is 210. And just see 212, where I've quoted whether the Vyas and Lingayat community institutions, religious, charitable, founded by members of these communities, are religious denominations or not, are questions which should be determined in its proper forum. Resort to the writ remedy in the first instance is misconceived and inappropriate. Forget 32 in a PIL. Even a writ is questioned. Forget 32 in a PIL. Then was 213, etc. Regarding issue A, which Justice Nagarata rightly raised, is 218. This is simple at 220 is the germ of that proposition.
I think 216 broadly sum up everything, that where
Yes.
there is a public injury and
If there's injury
then
to public
PIL should be maintained.
because of dereliction, so that example Justice Bakshi gave us, state is sitting and doing nothing, your lordship is having some very disastrous thing going on. Nobody is saying your lordship is hamstrung, your lordship is not. 216 gives that example. Now 220, the top line, is the proposition which Justice Nagarata raised in the beginning, which I put as a second. Only a person acting bona fide and having sufficient interest in the proceeding will have a locus standi to approach. And that will be 222 at page 119. To determining the validity of long-standing religious practice of a religious denomination in anyone's instance would require the Honorable Supreme Court to decide religious questions at the behest of persons who do not subscribe to this faith. I'm running around, but this is the heart of what I want to say. And in conclusion, 223. PILs by non-adherents is an intersection of dual wrong practices, both in regard of initiator of action and in the frame of the action. Even assuming without conceding that such proponents, initiators are permissible in some cases, they ought to be prohibited and eschewed in a class falling under 25 and 26. A, the effect of allowing a non-adherent to travel in the vehicle of a PIL is to permit one member of the society to hurt the religious sentiments of many others. B, since religion is uniquely an issue of faith, does not contemplate external and objective standards of review. Consequently, a non-adherent, the non-adherent has to be external. He has to be external. Consequently, a non-adherent cannot be allowed to impose an external standard without being even compelled to show how he is affected. Following upon the faith-based nature of religion, denomination, practice, religious group, it's a contradiction to expect a non-adherent to understand or deal. 121. Ex hypothesi, a non-adherent cannot be prejudiced. Such a non-adherent therefore admittedly claims maintainability or action by imposing the non-adherent's personal belief.
Then will you say that he has no locus standi at all?
That's the heading. That's the heading of this section.
No locus
No
standi.
locus standi. You can call it locus. You can call it. It's the same point. Yes, yes, absolutely yes. I have said so. I use the word locus. At 220. 220. At para 224, I've used the word locus. Now, your lordship's time is limited. Give me 3 to 4 minutes. This is important, and I'll stick to that time. On one page, on this Sabarimala issue. I'm not arguing the facts. Your lordship should know. Your lordship has heard so much of law. It can't be completely in an ivory tower in abstract. Relate it for 3 or 4 minutes to why we are saying what we are saying. I'll take not more than 3 or 4 minutes. Your lordship has already been very generous with the time. Your lordship has addendum C in that same. Now just allow me to make that. No, don't even read it. This Lord Ayyappa, I am told, has about 1,000 temples in India. Somebody says it's 1499, somebody says 1,000. Let us not get into that. The only sole temple of Lord Ayyappa, which has him in one form as a Nashtik Brahmacharya. The word Nashtik means an eternal Brahmacharya. It's the only one temple of Lord Ayyappa which worships Lord Ayyappa in that form. Now, the very foundation, this is at your lordship, page 7, one page is written there. The very foundation of the fame and prowess of this Lord and this deity is in the form only of Nashtik Brahmacharya. The only reason people revere him is because he has eschewed all forms of Grihastha and has adopted penance of a very high order, which includes celibacy and self-denial completely to an extreme position, which is why, when you go up, you need to do vratam, the ordinary people who worship, for 40 days before that, supposedly, 41 days, supposedly. I mean, you don't do it, it's a different matter, but that's a principle. Now we have to relate it to 14. My main argument is we are excluding females. First of all, remember, there is no exclusion of females. Females below 10 and above 50 are allowed. So it's not a gender per se. Second argument is, within the band of 10 to 50, you are making a subclassification of females who cannot go. Now, if I am able to show in Article 14 and 15 that this exclusion of supposedly fertile females, menstruating females, between the age of 10 to 50, their denial has a direct nexus with the object and the identity and the manifestation of the deity, then it's a valid classification. That's the legal argument when it goes to the facts. The validity of a classification between women below 10 and above 50 on the one hand, versus women between 10 and 50, has to be judged with what you are discussing. You're not discussing a toy shop. You're not discussing a restaurant. You're not discussing some other deity who has no connection. He is a celibate, eternal brahmacharya, who forbids all forms of grihastha ashram, chief of which is celibacy. Now, therefore, it is, of course, you can argue why is it not 11 years? Why is it not 49 years? It is assumed that fertile women in this age would be antithetical to the very manifestation and existence of the identity of the deity. You might not have Lord Ayyappa as an eternal brahmacharya. But these women can certainly visit Lord Ayyappa in 999 other temples. If they are so concerned in a PIL, why should they want to visit just that one temple? There's only one temple. So, you will apply these tests if you come down to pure law. 17, 14, etc. The exclusion has a direct, valid, proper, real, and genuine nexus with the identity of the temple you are discussing. That's what I elaborate where the facts come.
Just a block 10 to 50 or menstruating 10 to 50?
No, it is assumed that 10 to 50 fertile women. There is an assumption there is an ad hocism there. Your Lordship in Nakara has said all ages and all lines are necessarily arbitrary. If I had put 11, your Lordship could have asked why not 12. So all lines are arbitrary. It is assumed that fertile women will be in that age group. It may not be correct, but it's an idea. Basically, you will exclude all forms which are antithetical to the identity of the deity.
Interestingly, you may have some submission argument to say that these are the reason. This is a particular reason. By questioning why not 999 and why they are going to only one temple would be little harsh.
No, I'm not saying what you are thinking. I agree. I'm not saying that.
Not that tone, I suppose.
I'm not saying this.
That this is
I bow down. No.
Okay.
I'm saying something else. I'm glad I'm not business. I'm not saying these PIL petitioners or the women who should go to other temples. That's not my argument. I am saying on a valid classification, you can be excluded from what you are antithetical, but you have
posing that question.
But you have equal access to Lord Ayyappa in 1499 other temples. That's all I'm saying. It's not that you can never do darshan of Lord Ayyappa anywhere. But this particular form of Lord Ayyappa is not worshipped anywhere else. And if the belief, which is nobody says is an imaginary belief, is that Lord Ayyappa represents brahmacharya in his highest form. If that belief is genuine, then how can I or she or a PIL petitioner question that belief in a PIL? That's the issue. I'm not saying that this particular association can't go to other temples.
Is it the oldest temple of Lord Ayyappa?
Not be.
Well, let's see. There are 8 Delhi. I don't know. Maybe there are some older ones.
No, I can't see.
This is about 200 years, I
I
believe.
can't see that. Let's see.
We check it out. Please check it out.
Reconsecration took place in 1950.
But this form is worshipped only there.
250.
This form is worshipped only that one.
That's important. That's the most important part in the 14 and the 17 and the 25 test.
In fact, Lord, the Brother is sometimes taken. Other temples situated slightly.
So,
Present the deity having the unique characteristics, you find it only in Chile.
So, you have to judge contextually. We are not talking of women being excluded per se from going to a normal place. We are talking of a very special deity. Now, if I made an arbitrary, unknown, ridiculous rule about women without looking at the deity, then I am wrong. But I have not done that.
You are only highlighting the belief that.
Belief.
Thank you, Dr. Singh. Thank you
Deeply
very much.
obliged. Very deeply obliged.
Done, I think.
No.
Thank you very much.
It's very kind.